is registered under Section 8 of the POCSO Act. Accused persons were arrested. Thereafter, a cross POCSO case has been filed against us, saying that now we have molested their daughter. So, madam, case diaries of both cases may be possible.
And as we were discussing once, in other matters with other councils, that they get that clarification done because from the division bench as to whether this because there may be many situations where interim may be necessary.
Yes. This was one case, perhaps one otherwise
it may be necessary. That cannot be ruled out. So since it's a division bench,
yes,
and the notice, that sometimes in exigencies of the situation, interim can be granted without waiting for the notice, because the notice will take its own time. At that time, the person may get arrested also. So that is, in my opinion, that's necessary. So that is a division bench order, so which is silent on that aspect. So it needs to be clarified. Anyway, as Nawaz, learned counsel for the petitioner, and P. Bhattakur, invoking section 482 BNSS, the three petitioners herein are seeking anticipatory bail in connection with Morajhar PS case number 94 of 2026 under section so and so of the POCSO Act. The petitioners shall take steps up for notice upon respond number 2/informant on that, like that. Mr. Nawaz, learned counsel, submits that with an allegation of molestation of the daughter of
the petitioner number 2, my lord.
Petitioner number 2, an FIR was lodged, which was registered into Nagaon.
My lord, which was registered as Nagaon PS case
Nagaon
number
PS case number 409 of 2026. Full stop. It is further submitted that pursuant to lodging of that case, the instant case was lodged against the petitioners, which included the informant of the other case.
Not the informant, my lord, his family member.
Family member informed. The learned counsel prays for calling for both the case diaries. Should we? We can. Should we? Maybe. Call for the case diary of Nagaon PS case number 409 of this thing. Prosecution shall do the needful to procure both the case diaries.
There's one additional prayer, my lord. In the cause list, your lordship will see the name of the petitioner number 1 is Imdadul Haq. I have checked with the records, it is correctly there, but in the system it has been wrongly shown with a additional K in the Haq, my lord.
Okay.
Registry has made this perhaps, my lord, inadvertently. Registry may be directed to verify the names of the petitioners and make necessary correction.
It is pointed out by the learned counsel that although the name of petitioner number 1 is Imdadul Haq, but in the cause list, it is indicated as Imdadul Haq K and 2 others, full stop. The registry may look into the matter towards verifying the name, and if found erroneous, reflect the correct name of the petitioner number 1 on the next and subsequent dates. Okay. List on
My lord,
this week or after?
After vacation, when notice will have to be served. 15/7.
14 or 15? 14.
14/7.
15/7.
15/7. I'm deeply aware.
If there is an application for anticipatory bail, your lordship will find the FIR. Lordship, at the typed copy, your lordship will find at page 24, lordship.
24.
24, lordship, the typed copy.
Yes.
Lordship, may I read from the second paragraph? It is mentioned that rupees 10.94 crore was funded by Agency Franchised Development (AFD) for procurement of vehicles under phase 2 of the Assam project on.
Where are you reading?
Page 24, second paragraph. Lordship. There is an FIR dated 16/3/2024.
Yes.
May I read it, Lordship? It is mentioned that rupees 10.94 crore was funded by the Agency Franchised Development for procurement of vehicles under phase 2 Assam project on Forest and Biodiversity Conservation Society. In this regard, information related to notice inviting tender was advertised online and in the newspapers. 2 parties submitted bid documents, namely so and so, The SPL Services Private Limited was awarded the tender and accordingly supplied 129 different makes and models.
Hmm.
Now, Lordship, the second paragraph. This is, Lordship, I am an IFS officer of 1992 batch.
Hmm.
At the relevant point of time, I was serving as the project director. Lordship, the second paragraph. Ms. Momi Dihingya, AFS so-and-so, was not present in the BWation meeting. However, PDAPFBC, that is the petitioner hearing, Lordship, after completion of the evaluation, informed AFT that she had given consent by email. Lordship, this is the only allegation against me in the entire affair. Now, your Lordship will kindly see the next slide. This is the allegation that I had stated that she had consented, but she denied that. Next line, your Lordship will see. But Ms. Momi Dihingya denied being informed about the meeting and giving her consent to send any email. This is important, Lordship. Further, she had approved the payment after delivery of the vehicles and she was well aware of the tender process.
Okay.
Lordship, therefore, the tender was successfully completed. The vehicles were delivered. There was no dispute to that.
Hmm.
Now, your Lordship will see the next paragraph. If I may read through, your Lordship, it is suspected that anomalies and illegalities had occurred in the process tendering and procurement of vehicles. Once Sri so-and-so attended the bid opening and signed on behalf of SBL Knowledge, although he was not the authorized representative. Industrial farm equipment was absent on the date of bid opening and had not taken part in the tender process. The documents of industrial farm and equipment submitted in the bid were suspected to be false, were put in by SBL so-and-so. Then your Lordship will see the next paragraph. The then PD APFBC, namely Sri so-and-so, the petitioner hearing, sought 4 additional documents from SBL so-and-so. These documents were submitted by Shri Manoj Jacob, Vice President of SBL Knowledge Services Private Limited, with a forwarding letter. There were discrepancies found in the date of documents. SBL Knowledge Services had also submitted experience certificates from State Bank of India and Nagaland Police as supporting documents for their experience in supplying vehicles. However, SBI had not issued the experience certificate submitted by SBI, and it was suspected to be forged. The work order and completion certificate submitted by SPL Knowledge in respect of Nagaland Police was also reported to be manufactured and fabricated documents. The Nagaland Police had in fact issued the work order and completion certificate to industrial farm equipment, so and so. Now, the next line, Lordship, page 26 top. SBL Knowledge Services Private Limited had participated in the bidding process, knowing fully well that experience was one of the preconditions for participating in the tender process. It is suspected that SBL Knowledge Services had resorted to forgery and submitted fake and fabricated documents to establish their experience in vehicles. Now, these false and fabricated documents purportedly were submitted by SBL Knowledge.
Tender was already given to this SBI.
SBL Knowledge, Lordship.
SBL.
Yes, Lordship. Now, also in the next paragraph in page 26, a few bank guarantees were submitted, which the authority subsequently, the bank authority stated that it was never issued by them. Now, your Lordship will see the third paragraph in page 26. Suspicious cash deposits, Lordship. May I read it?
Yes.
Suspicious cash deposits were noticed in the bank account of Abdul Wahid Chaudhary, Senior Procurement Specialist, APFBC, and his family members could not be satisfactorily explained by him. Lordship, this person has been granted the privilege of anticipatory bail by this Honorable Court in the year 2024. The person from whom suspected cash deposits were found. Now, on the next slide, the suspicion. It is suspected that SBL Knowledge Services Private Limited, in conspiracy with Shri KSP Pawan Kumar, the petitioner hearing, and other officers and staff of Project Management Unit APFBC, vitiated the tender process not only by submitting forged documents in its own bid documents, but also by submitting spurious bid in the name of another party by impersonation, bribery, cheating, and forgery of the document, with malafide intention of winning the tenders through manipulation and criminal acts. According to Lordship, I was named in the FIR page 27, serial number 1, Lordship, along with 7 other persons. And the case was registered, Lordship, at page 28 under sections 120B, 406, 409.
This petition is filed by?
Filed by the project director, the then project director, Lordship, KSP Pawan Kumar.
Is the accused number 1?
Accused number 1. Yes.
Lordship, now the FIR was registered under sections 120B, 406, 409, 419, 420.
PC Act is also there.
PC Act is also there. But your Lordship has seen in the FIR, the only allegations, solitary allegation against me was that I had wrongly informed the AFT that consent was given.
What was the earlier this thing? What was this? Central Administrative Tribunal, different thing.
Lordship, Lordship, the FIR was registered. It continued. The petitioner was never called for examination or to appear before the IF. Now, in the meantime, Lordship, the petitioner approached the Honorable Central Administrative Tribunal because his promotion
was held up.
Promotion was denied on the ground that FIR was pending. Now, Lordship, the Honorable Central Administrative Tribunal passed an order that on the ground of FIR is pending, you cannot withhold promotion. The relevant, your lordship will find that page, the ultimate direction.
That's okay, it's fair.
No, lordship, why that may be a bit relevant. This order of the Honorable Tribunal, lordship, this order of the Honorable Tribunal was widely reported across various sections of media. On 10th June, lordship, this was also reported in the Assam Tribune. That I have annexed, lordship, page 55.
That's okay, but now let us, yeah.
At this stage, because prevention of PC Act is.
Of course, case diary will be necessary.
Case diary will be-
Lordship will only,
Case diary will-
lordship will only consider one aspect, lordship.
And not only the allegation is that, my lord, that he is the main person of that, my lord, tender committee.
100 and, how many vehicles? 100 and,
129 vehicles.
that's quite a bit of money, that will be,
Lordship.
that will be quite a bit of money.
Lordship, if I may.
Yes,
lordship,
complete your submission.
Yes. Lordship, 10th, this publication was done in the Assam Tribune. On 11th, lordship, the very next day, after 2 years, there was no notice to me. Immediately on the very next day, I am called for lordship to appear before the investigating officer. That notice, your lordship will find at page 33.
What is the date of the FIR? This one?
Lordship, 16/3/2024.
I see.
16/3/2024, your lordship will see the notice is at page 32. This is on lordship 11 June 2026. Immediately on the next day, 10th it was published, saying that FIR cannot be a ground. 11th June, they issue me this notice. Now, lordship, at that point of time, I was in Hyderabad for medical treatment. I had accordingly intimated the investigating officer that I shall be in town after 20th, therefore I may be called on any day after 20th. Now, lordship, this entire case pertains to documentary evidence. Bank guarantees, forged experience certificates, all those are in the possession of the IO. And lordship, this person was relieved from the post of project director in 2022 November, before the FIR came into existence. Now, lordship, there is no likelihood of.
Yeah, you heard, Mr.
A. Chakraborty, lordship.
A. Chakraborty, learned counsel for the petitioner. And P. Bhattakur, learned additional PP for the state, invoking section 482 BNSS. The petitioner, namely KBS Pawan Kumar, is seeking anticipatory bail in connection with ACB PS case number 24 of 2024 under so and so. Full stop. The said case was registered based on an FIR dated 16/3/2024. Lodged by Sri Barun Purkast, Directorate of Vigilance, from the Directorate of Vigilance and Anti-Corruption, Assam. Full stop. The gist of the allegations was that tender was floated for purchase of 129 vehicles for Assam Project on Forest and Biodiversity Conservation Society, APFBC, of which the petitioner was the then project director. Full stop. It is stated in the FIR that rupees 10.94 crores was funded by Agnes, is a French name, Agnes, AGNC Franchise D Development, AFD, right at page 24, you'll see, for purchase of vehicles. Accordingly, after floating of tender, 129 vehicles of different makes and models were purchased. There were only two bidders, being Industrial Farm and Equipment Private Limited and SBL Knowledge Services Private Limited. The tender was awarded to SBL Knowledge Services Private Limited. Full stop. However, later it is alleged that later it was found that many of the eligibility documents, some of the eligibility documents submitted by the successful bidder were manufactured and forced, including some documents from Nagaland. And it is alleged that manipulation in the tender process was done to favor the said bidder. Full stop. In the FIR, 8 persons are named and others. The full stop. The petitioner herein is named as the accused number one in the affair. And he was stated as the then project director. He stated as the then project director, APFDC. The learned counsel for the petitioner also submits that due to the pendency of this FIR, the promotion of the petitioner was held up, whereupon he approached the Central Administrative Tribunal, Gauhati. And the said tribunal, by the order dated 14/5/2026 in original application, so and so, page 38, was pleased to grant relief to him. Stuff. What was the relief? That the promotion can be processed.
Lordship, promotion should be given page 54. Promotion to be given with retrospective effect from 1/1 to
Grant him relief by
page 54, Lordship.
directing for granting of promotion to him. The learned counsel submits that the FIR, he was summoned in this FIR after the said order. The learned counsel prays for interim protection. The learned, on the other hand, the learned additional PP, Mr. Bhattakur, submits that considering the nature of the allegations at this stage, only case diary may be called for. I've given my consideration to the matter. I have gone through the allegations in the FIR. Call for the case diary of so and so, ACB police station case number so and so, so and so, so and so. At this stage, let it be.
Lordship,
No interview.
Lordship may kindly consider the interim because it's entirely a case of documentary evidence.
Don't
And if I
not
magistrate,
that.
Lordship, I will be placed on the suspension, negating the effect.
The
And-
prayer for interim bail stands rejected at this stage. Okay. Next.
PD, my lord, on
Date will be
17/7,
give it earlier as soon as it opens.
14/7.
14/7.
Obliged, Lordship.
May I please? Your
Yes.
Lordship? Lordship, this application has been filed under section 482 for grant of PRS bail to the petitioner, Lordship. In this case, Lordship, a law point is involved that no notice under section 35(3) has been issued upon the petitioner, Lordship, because in this case, all the sections involved are within the 7 years, Lordship.
Hmm.
Otherwise, the case is under
Folks.
POCSO, Lordship. But my only contention is that, Lordship, that because it has been decided by many decisions of the Supreme Court as well as our High Court, Lordship.
If not noticed, then they have to,
This may be, and regarding 35(3), my lord, because this is AB, forwarding report is also not annexed, so I will have to cross check.
but there's no forwarding report.
Not
Because it's
AB, no.
AB only.
AB only, that's why, my lord, so I
You
will have to cross.
find out, can you get the case diary and
Yes,
notice?
notice and-
Case diary, we can get it this week,
Yes.
but the notice, I don't know whether how fast it will be. But
will-
if you want, we can take a chance.
Yes.
If you want, we can take a chance. You, Chaudhary, Learned Counsel, and P. Bhattakur. Call for the case diary of Morioni, PS case number 32 of 2026 under so and so section. Full stop. Issue notice upon respond number 2 like that. Informant, so and so, full stop. Mr. Chaudhary, Learned Counsel submits that the penal provision in the instant case is punishable up to 7 years. And therefore, and in this context, the IO has not given any notice to the petitioner, accused petitioner under section 35(3) of the BNSS. And that the same constitutes a procedural infirmity. So when can you get it? But CD, we can get it, but notice, I don't know.
Before vacation.
Before
Notice.
this.
Immediately after vacation.
Immediately after vacation.
14,
13, 14.
14/7.
Obliged, Your Lordship.
In hearing BA 19/16.
Oh, yo. Orders. I thought or bail hearing also below. Six orders. No. For railway or or no, orders to appeal. Yes.
My lord, in this case, the interim has been granted, my lord, and we are facing the trial, my lord.
Mhm.
Last of it, first interim order to the my lord, accused persons, my lord.
Mhm.
Thereafter, my lord, 18/6/2023 for physical appearance, my lord.
Okay.
They have, perhaps not appeared, my lord, after granting my lord interim bail, my lord.
Just a minute. Let me refresh. The trial is going on.
My lord.
They have not appeared.
Facing, my lord.
No, they have not appeared.
After interim not appeared, my
They
lord.
should have
And
appeared.
There is 18/6 for appearance, my
They
lord.
should have appeared. Anyway, it should appear because trial is going on.
My lord, on the first instance, my lord, we have taken steps, my lord. Due to some reason, my lord, and on the last yesterday, on Saturday, my lord,
Mhm.
Friday, my lord,
Mhm.
they were appeared.
So that may not be,
My lord, not available, only 18/6, my lord.
may not be reflected. Last Friday was the date,
Right.
as per your instruction. What do you say? They're already on interim bail, so it can be made absolute, I think.
With the condition that they.
But cases of homicide, and the investigation is completed anyway. So you take it from here, huh, Mr. Counsel. Azad, and you para last order, para 1, 2, 3, 4, for not 4, 5. Anticipatory bail by this court. Up to that, you're right. You can lift it. Full stop. On the last date, that is 19/5/2026, both the petitioners herein were granted interim regular bail due to completion of investigation and an aspect of projected procedural infirmity in the arrest of petitioner number 1.
Oh, yes.
The scan TCR is available. The learned additional people submits that pursuant to grant of interim, they have not appeared. However, the learned counsel submits that as per his instruction, on the last Friday, the petitioners have appeared before the learned trial court and facing the trial. Considering that the case is at the stage of trial and upon completion of investigation, I do not deem it necessary to cancel the anticipatory regular interim bail. Accordingly, the interim bail granted by order dated 19/5 is hereby made absolute, subject to the following conditions. They shall be available for the remaining for the trial. Number 2, shall not hamper or tamper with evidence or try to influence any witnesses. They shall not harm or harass the informant side in any manner. Violation of the bail conditions would make the bail liable to be cancelled,
My lord,
hence disposed of
my lord, subject to correction, my lord. Friday is 19, my lord. On 19.
on 19th.
19.
19th.
Friday.
Friday, 19th June. That's okay?
Obligation.
Item number 70.
Your matter, Mr. Sos. Your matter.
Yes, my lord. Bail hearing, my lord. I am behind by 121 days, my lord.
Mhm.
This is in the neighborhood.
Commercial quantity.
Yes, commercial quantity. Actually,
My lord, here I have gone through the record, my lord. Here charge is yet to be framed, my lord.
Hmm.
Only
Because since it is commercial quantity and we
Commercial
have to see on merits, then you
From
have to
their
see
point-
37. Oh, it is sitting here.
from their position, it was recovered, my lord. And next date, it was already over, my lord, 21/5/26 for production and copy, my lord.
Hmm.
Lord, she may call for also up to date CD, my lord, up to the status report, my lord.
but that is in the, your Roshi may call, but question is that, after the charge sheet, immediately charge sheet should be framed. It is being delayed.
That we can give, but instead of why keep it pending or dispose it of? Because merits,
From their conscious position, it was recovered from their conscious position, my lord. Here, 30 records of 37 will come, my lord.
that is, if on merits, we have to see that, we have to see it.
And otherwise, my lord, it was fixed for people. Let some of the witnesses, vital witnesses may be examined also, my lord. Yeah.
Yes. How many witnesses in that charge sheet, sir?
7 witnesses.
Well, it can be completed, I think. Trial can be completed. Where are the Caesar witnesses? Have you marked? Caesar witness.
My lord, I take your Lordship 36 kindly, but section 36 has not been complied here. There is no, I have annexed the order, page 23, your Lordship will get me. No independent witness is there, or any relative was served. Page 23, 24.
The coordinate bench has submitted, my lord, several judgment, it has mentioned that 147 and 48 are applied, my lord.
Hmm.
My lord, there is no necessity for 36, my lord. Here in the, my lord.
Is it?
My
My
lord,
lord, yes, my learned friend complete first.
Okay, yeah.
and 47 and 46, perhaps it is complied, my lord. 47, 48 complied, my lord. 48, it was clearly mentioned about the reason of arrest and grounds of arrest, my lord. And it was mentioned.
Mhm.
Hereafter,
There,
Lordship may kindly page again, my lord, page 47, my lord. The rejection order of the trial court, my lord.
Page 47 of the bill petition.
Appeal petition, my lord. Uh, My lord, 48, my lord, page 48, my lord. Last but one, my lord. It further appears, my lord.
Yes.
That's it, got it. It further appears that notice under section 41 were issued to both the accused person and notices under section 48 were also issued to the relative friend or nominated persons of the accused person.
48 is okay, I think.
Perusal of the record further reveals that higher order so cursor reveals that guidelines of so and so. Further, my lord, on perusal of the arrest memo issued under section so and so, it appears that same do not bear the signature of any witness, either a family member or a respectable person of the locality.
Yes.
However, section 36C provides.
Hmm.
Let's make again 1 second, my lord. 36C, my lord. May I read, my lord?
Provides that every police officer
Provision,
making an
madam.
assault inform the
Madam.
person arrested
Madam.
unless the memorandum is attested by a member of the family.
Family, my lord.
That he has a right to be, have a relative or friend named by to be informed.
My lord.
There's no signature of any, but the concerned officer has omission, no the registration, non-compliance.
It is not the correct.
I don't
Provision
know,
of law.
actually, both have separate purposes, actually, the
Yes.
arrest memo and
My lord,
this. Other-
thereafter, in the instant case, it was mentioned, my lord. Thereafter, my lord.
Some coordinate bench judgment
my
is there?
lord, my judgment, sir.
You have, which is now. Fix it tomorrow, then you
My lord,
get the
thereafter
judgment.
tomorrow, my lord.
Till tomorrow?
My lord.
No,
Thereafter.
no, not tomorrow, my lord.
Yeah.
It will come on, come. They
They
will
have to-
come Thursday, my lord, Thursday, my lord, Thursday.
In the meantime, I will put it to judgment.
My lord, regarding 36, my lord, there are 6 judgments of different courts, my lord.
Mhm.
And in most of the cases, judgment complied, but in 2 or 1 court, it said that it has not been.
36 is the taking signature of witnesses, not necessarily relatives, some
Right.
witnesses of the locality,
Yes.
some witnesses of the locality where he was arrested.
Here in the judgment, it was mentioned that if it is not also done, my lord, if 48 is complied, my lord, then it is not
We
necessary.
cannot go beyond the.
Both have separate purposes, actually.
Yes.
Anyway, but
My lord.
I may not depart because if there are coordinate bench on this point, and then again, it's a matter of principle, becomes a matter of principle.
Yes.
Then either I have to follow or we have to refer to larger bench.
Exactly. That's why you have.
So if it is there,
submitted.
so I have to follow. Otherwise, if I disagree, I have to refer. So You get it and study it.
Fine.
And SC Biswas, learned counsel for the petitioner, and Sharma, learned additional PP for the state. The petitioners, the two petitioners are seeking regular bail in connection with NDPS case 46 of 2026. Arising within bracket, arising out of Jihir Ghat PS case number 8 of 26 under so-and-so section of the NDPS Act. They were arrested on 22/2/2026. Full stop. The case has already been charge sheeted and pending for framing of charge. Full stop. The scan record has been received. Full stop. The learned Mr. Biswas, learned counsel, submits that the arrest memo given under section 35 of the BNSS does not bear signature of any other witnesses. Full stop. In this context, the learned additional PP submits that the notices are under 47, 48 have been duly provided and complied with. And in the context of the same, there are decisions of coordinate bench holding that any such infirmity in the notice under 35 will not constitute a fatal infirmity in the arrest procedure, entitling the petitioner to any bail. He seeks to submit some case law. List the matter. Scan TCR is available. List the matter on what will be the date? 25, I think.
Yes.
May I please, Your Lordship?
Yes.
Your Lordship, there is a violation of section 36 of BNSS, my Lord. And in DK Basu versus State of West Bengal, Honorable Supreme Court already raised down the police personnel.
What is the violation?
Page number 26, my Lord, in the arrest memo.
Same.
Same,
No signature.
same, my Lord.
And say we come to the same issue then.
Yes.
47 and 48 complied with.
No, 48 or not compliant, my Lord.
40,
And
that
I
then,
have already annexed the judgment of the coordinate bench, my Lord, and you see page number 32.
if 48 is not compliant, then you'll get the benefit. But as far as that issue is concerned, we just let us see those judgments which we're planning to be submitted on Thursday. Mr.
Page number
Botaku?
32, my Lord.
Here, my lord, difficulty is that 48 is, my lord, WT message, my lord.
WT message it can be, but it has
Yes.
to be delivered.
Yes.
The content should be sufficient and it should be delivered to the person.
And today only, my lord.
And if it is refused, a similar endorsement should be made.
Yes,
Because sometimes it can be refused also.
to the concerned police station, my lord, WT message sent after, thereafter, my lord, regarding receipt, my lord. I will have to get instruction, my lord, today, otherwise only 48 notice and 47 I got from the IO, my lord, for WhatsApp, my lord. In the CD, my lord, that was in fact not available. Today, after going through the CD, I contacted him, why that, my lord, 47 and 48 is not available in the CD.
So what did he send you?
That is, my lord, he sent me through WhatsApp,
Let's have a
the
look.
printed copy of the 47 and 48.
As per these documents, it is compliant.
WT message sent to 48, whether they have sent.
Let me have a look, huh? Please.
Your
The
lordship,
police only said WD message, but it has not received by the family member, my Lord.
Yeah, that is why I said it has to be delivered or if refused, an endorsement taken.
And my Lord, this procedure relates amount to fundamental rights of the accused person, my Lord.
Because sometimes it can be refused also. So endorsement has to be taken. The directions have been given on these lines actually already.
Otherwise, I will have to again get into, because today I got my lord, little time.
You may need to take instructions.
Otherwise, further instruction, I did first page, that is my lord, 48 notice regarding two accused.
47 notice is
No,
sufficient.
47, 48, my lord, one page, that is two accused person, Nazrul Islam and one, my lord,
If it is only this, it will not suffice.
Yes.
Ask him, you
Whether
take
that-
instructions and ask him to tell,
any return message.
no,
receipt of bill.
ask him to tell the fact
Yes,
truthfully, whether it is this or a copy of this has been sent.
yes.
Well, arrest memo is a different thing, my lord.
Plus the arrest memo also
Different thing.
does not have any
The
signature,
judgment of the court in advance, my lord. I have already annexed.
does not have any signature, it seems.
My
Yeah,
lord.
nothing.
Can I see, my lord, page number 32, my lord.
Yeah,
This-
this along with the item number 7. you
Okay.
present it. I will-
Do that, huh? Let him take the instruction, and a similar, issue is also there. On 25th, we'll take a call on this. But I'll record your submission. Heard, Mr.
Similar judgment there, my lord.
Your good name, please?
They are plus, my lord.
J. Abbas, learned counsel for the petitioner, and P. Bhattakur. Invoking 483 BNSS, the petitioner seeking regular bail in connection with Bajari Chera PS case number 18 of 26 under so and so section of the NDPS Act. He was arrested on 15/4/2026. The learned counsel submits that the arrest memo does not bear a signature of any witnesses. Full stop. It is also submitted that there is no compliance with the notice under section 48 BNSS. The learned additional PP fairly submits that he could not find the notices in the case diary and therefore sought some feedback from the IO, whereupon a notice under 47 was sent to him electronically, as also a WT message about informing the family member of the arrestee. Full stop. However, it is not clear from the WT message as to whether the notice under section 48 BNSS, as is required under law, has been sent to the family member. Full stop. The learned additional PP seeks to take some further instructions on the matter. The case diary may be written. List the matter on 25th. Okay.
Yes.
25th.
And regarding one other decision of the Supreme Court recently, my lord, that is in State of Punjab versus Balraj Singh. Well, I would like to point out only one paragraph 22, because one of the judgment that was passed of the Bihan Kumar, one of the judges, my lord, Honorable Justice N. Koteswar Singh, he was also in this judgment. Here, my lord, in paragraph 22, I am just pointing out, my lord.
Balbir Singh?
Yes, State of Punjab versus Balraj Singh, alias Bingla, my lord. I will hand over one copy, my lord. Regarding my lord NTPS cases.
Para?
Para 22, my lord.
Okay.
However, we note that recently this court in Taslim Ahmed versus State Government of NCT of Delhi has referred the question of concerning the approach of constitutional courts in bail matters under special statutes, where Article 21, prolonged incarceration and statutory restrictions intersect. In view of the said reference, we do not wish to deliberate on this issue further, save and accept that in our view, paramount consideration is nothing but interest of justice for all. Should there be any conflict between this is important, my lord. Should there be any conflict between the sovereignty of country and personal liberty, undoubtedly the former shall prevail, particularly when a war is waged against the nation, but in the form of supply of drugs, which specially affects the national economy and health of the people.
So if the exposition of law is very clear, then it will be easier for us to follow. So the thing is that whether this interplay has to be seen. No? Now we know 47 notice and 48 notice. If there is no compliance,
Yes.
then it's a fatal infirmity. Now, if the arrest memo does not have signatures of witnesses, some cases it has been held that on its own it has been held in coordinate bench that will also be a infirmity, fatal infirmity. Now, the other point which came up in the previous bail application, that suppose there is compliance with 47, 48, but this defect in the arrest memo, then will that be curable defect? Will it save the arrest procedure? So in other words, whether this can be seen in relation to one another, that if there are compliance with 47, or they have to be independently complied with properly. This is the
However, there are three coordinate benches judgment of our High Court. Now,
give
recently
it.
considering section 36C And my lord, 48 rejected the, if my lord 40 in 36.
We'll see that.
My lord, the signature of the witness is also not there, my lord. 48 if complied with, then rejected. My lord.
That we can see. And this actually is a foundation for some more laws which will come.
Yes.
Violating the fundamental that cannot be known to the
In the
With-
form of drug abuse.
with 48 is totally different.
In my opinion, it is better to, lay down in this form that each of those notices should be followed properly. Then it will be easier to implement this. That all of this, they are not substitute for one another. They have to be followed independently. And if yes, good. If not, it will be easier to follow like that. Otherwise, how will you correlate? To what extent you will correlate? That is the problem. That problem we'll face anyway on Thursday.
Your Lordship.
Yeah.
In this matter, Lordship, the ground is mainly taken for non-compliance of the notice under 48. Already, one of the co-accusees has been alleged by this very court in a very recent proceedings, and already he has now been detained for 552 days, with the trial still not yet started, and it is in the stage of appearance. So, considering the fact that there was a total non-compliance of 48, which has been very elaborately and in detailed manner, this honorable court has taken up and has passed the bail order for the co-accused. Now, coming to the facts of this particular person.
In this case also,
yes, here
it's not compliant.
Yes, we have gone through the record, and in fact we have kindly perused to page number 54.
Lordship, I have a prayer, Lordship.
I'll come to you. Yes.
54, Lordship.
Tell me. Yes.
Allow us 3-4 days time to file our objection, Lordship.
Because let me. Okay.
Lordship, before
Yes, Lordship, on Friday, Lordship.
I have an objection. Why? Because Lordship, on 1st of June they have received the copy. Now 21 days have already passed. Now the vacation ban already on from 28 the vacation will start. So
Let me
this
see
is-
the 48 notice. Let me see.
No, before that, Lordship, I want to take you to draw your attention to page number 54. That is the DRI application which they had filed after the arrest of these two accused. This is very important.
54.
For 54, we have annexed this application which they had filed before the magistrate. Come to the prayer portion. Lordship, page number 54.
Yes.
Lordship, in the premises of the above facts and circumstances, it is respectfully prayed that your honor may be pleased to: number 1, peruse the seizure list, memo of the goods seized, panchanama, seized goods, notice under section 47 of BNSS, comma, arrest memos, seizure photographs, medical reports, certificate under section 63 4C of the BSA 2023, along with SD card with the SI identification number. From here only we see that there is no submission of the notice under 48. Even after arrest, before the like when they are filing the application also, they have not been able to produce it. And even after filing of the application, now we go to the rejection order now. This particular petitioner had opted for this bail application before the trial court. Now we go to rejection order, that is page number 174, Lordship. 171, Lordship. 171. Para 12, Lordship.
171.
Page number 171.
Hmm.
Lordship.
Yes.
The grounds for arrest were communicated to the accused persons at the time of their arrest. Okay, we totally believe to their version. This court is of the considered opinion that given the accused persons were intercepted with the vehicle and the methamphetamine tablets were recovered from a secret cavity within that vehicle in their presence, it is implausible that they were unaware of the reasons for their arrest. The investigating agency issued a notice under section 47 of the BNSS to the accused persons during their arrest. There is no notice under section 48 of the BNSS.
That's okay. So
Trial court also had perused this particular record.
So do one thing. You produce this is at the stage of investigation.
No, charge sheet already filed.
Already fine.
Lordship, on this ground, Lordship, on 48.
Where's the record?
TCR is already available.
Raja, anyway, so can you suppose you file the objection on Thursday, we can take it up on Friday.
Friday.
That will be better.
On Lordship, 48 ground.
Because since he obviously you will have, because he says that the notice was given on 1st June. So he was expecting that you will file something.
And on
No, you file it on Thursday and we'll fix this on Thursday. But in the meantime, you exchange the objection. You file the objection and exchange it with him.
Absolutely. They
That's
can
fine.
give us a soft copy
That's
of
fine.
No issue.
Because at that time, it was arrested in December 24. At that time, it was not known.
In fact, Lordship, the law has now been made up in such a way. In the recent judgment, after this Balraj Singh, there is a judgment, Dr. Rajinder Rajan, 1st of April, where it has been crystallized now, because there has been two category of now classes have come of the arrestees. Like no one prior to the passing of the Pankaj Bansal, and now after Pankaj Bansal, Prabir Prokraster, then Bihan Kumar, then Mihir Rajesh Shah, and now what has happened is that in between the Darshan Kumar also came.
What is the name of the decision you said? Latest?
Yes, Dr.
Balraj
Rajinder Rajan versus State of Lordship.
Supreme Court.
Yes, Supreme Court Judge.
Rajinder Rajan.
Yeah, Dr. Rajinder Rajan, NDPS case, Lordship.
Oh, I'll see that. Huh? Do it. Try. Rajinder Rajan. Rajinder Rajan.
Dr. Rajinder Rajan.
Do you by any chance know the date of the judgment?
Yes, 1st of April,
Then
2026.
it becomes very easy to take out actually. 1st of April 2026.
Union of India.
Dates up.
Dr. Rajinder Rajan versus Union of India.
Supreme Court
Here it has
said-
been very well, it has been now crystallized. The law is crystallized.
Okay, very good.
Because there has been so many discrepancies after so many coordinate benches, and even the Supreme Court coordinate benches, they have come up with different verdicts on the mandatory compliance of this 48. Now this Rajinder Rajan is very important, so that these particular discrepancies will let down to rest now till the time that new law is developed.
Good. Thank you.
Yes,
Give it
pleasure.
to me. So we'll see that. We'll see. The clearer the law, the better.
Yes.
For everyone, right? So, Mr. Mehdi, learned counsel for the petitioner, and M. Deka, learned standing counsel, DRI. Full stop. The petitioner who was arrested on 17/12/2024 in this case, is seeking regular bail in connection with NDPS case number 147 of 25, arising out of DRI. It is, trial has not started.
No, not sure. It is on appearance stage. Next date is on 22/7.
It is submitted, the case, that investigation has been, charge sheet has been submitted, but the case is at the stage of appearance and trial is not commenced, full stop. It is submitted that the petitioner is seeking bail on the ground of, mainly on the ground of non-compliance with the notice on the 48 BNSS. And that in this context, co-accused was granted bail by this court by order dated so and so, 6/5/2026 and BA 466 of 2026. Ms. Deka, learned standing counsel DRI submits that the prosecution would like to file a written objection. Full stop. Semicolon, to which the learned counsel for petitioner submits that the copy of the petition has been furnished on 1st June itself. Nevertheless, the prosecuting agency shall endeavor to file the written objection, if any, by Thursday of this week. Full stop. List the matter on 25th.
There is a correction, counsel for DRL, Lordship. Counsel for DRL. I'm not a standing counsel.
Counsel, no problem. No
Any
problem.
of them.
Counsel for DRI, no.
Obligement.
20.
May it please your lordship, my lord, may kindly pass over the matter.
After some time?
Yes, my lord. My lord, my senior is on legs. Obliged.
Okay.
21.
May it please your lordship.
Yes.
The petitioner is behind the bar for the last 392 days, lordship.
Okay.
Informant as well as the victim already examined, lordship. There is a violation of section 36 and section 62 of the BNSS, lordship. And in this regard, lordship, several judgments have been passed by the coordinate bench of this honorable court, your lordship, relying the DK Basu judgment, lordship.
Okay, just a minute. We have noticed, no? We have noticed you are appearing for the informant. That's fine. Second bail application.
Including a judgment of your lordship.
Okay.
Section 36 and section 62 of the BNS.
Just a moment. Okay, so there is no signature, there are no signatures.
No signature.
And what about 47, 48 notice? They complied,
Lordship.
complied.
I have also annexed the 47-48
So we can
My
go back to that issue again and again.
My lord, here, let's say before starting my topic, my lord, here earlier it was rejected, my lord.
Yes, yes, subsequent bill.
POCSO matter, my lord. POCSO matter, victim is 11 years old, my lord.
Have you annexed the earlier order?
Lordship, I have annexed the earlier order, Lordship.
26, my lord.
Earlier order was rejected on the ground of Lordship.
It was 11 years of age, my lord, in one,
6-5 it was rejected,
my lord,
Lordship,
on 6-5.
my lord, it was rejected.
this issue was not
My
discussed.
lord, this issue was not my lord, discussed in the, as it was in the POCSO case, my lord. Here, if they taken the plea, my lord, then it will, on that day, will again argue.
Pardon? Hmm?
In the date fixed, my lord, day after tomorrow, my lord, we will argue on the points along with my lord. If they are taken the grounds of 36, my lord.
Lordship judgment is also there and
Yeah, we have passed some
Lordship,
judgments, that's true.
section
But
30.
this correlation which you have brought, na, if there is compliance with 48,
Right.
but no compliance with 36, that is a new territory
My lord.
for me.
Lordship, here in section 36, Lordship,
Hmm.
36B, then C, Lordship, and is there, not or is there, Lordship.
Hmm.
Here and is there, Lordship. And, Lordship.
Hmm.
Who will place the
What is
judgment?
the stage of the trial? Victim examine,
My lord, only 2 witnesses are yet
Wait.
remain, my lord.
remain,
Remain, my lord.
out of
Out of 6, my lord, 4 witnesses already.
already examined. Please make your summation, what you want to say today.
একদম serious allegation, my lord. In her deposition as PW2, my lord. I pledge mark, my lord, in her deposition, my lord. And the trial is at the verge of my lord confusion, my lord. At this
Witnesses
stage,
yet
my
to
lord,
be examined, Lordship, 392 days behind the bars.
whatever may be, my lord, 11 years of old age girl, my lord. And
Not on
is
very
the
close.
50 years of my lord. Petitioner, my lord.
Okay,
I am not placing the case on merit, Lordship.
that's okay.
Only on the period of detention, Lordship, and
Of
section
course,
36.
you will be subject to a fair trial, but the thing is that, so
Lordship judgment is there, Lordship, Abdul Sheikh, Lordship. On the basis of DK Bazu's, relying on the DK Bazu's judgment of the Honorable Supreme Court of India. This order was passed, Lordship.
But here
It
the
is also a POSCO case, Lordship.
new development, my lord, here some of the coordinate benches, my lord, as I have.
in the meantime,
Coordinate
so it gets
Passed
conflict,
some judgment.
gets conflict.
Regarding coordinate benches judgment, Lordship, I have also placed some judgment of the coordinate bench on the same subject matter, Lordship. 3 judgments I have.
So if there are conflicts, then it
My
has to be,
lord, my
laid down by division bench clearly as to what will be, As I said,
My
in my humble opinion, it will be easier to follow
My lord.
if it is standalone. That each of the notices you have to follow properly.
Lordship.
Otherwise, if you have to correlate, then to what extent you'll do? So this much is complied, therefore the non-compliance will this, because everything has a purpose.
Lordship.
Arrest memo has to be signed by witnesses, that has a purpose. 48 has a purpose, 47 has a purpose, right? So if it is, if we mix up, then implementation will be more confused. It's better we keep it separate actually.
Right.
Keep it separate, tell the police investigating agency to comply with. Of course, you can always decide whether not having, as a principle of law, you can always decide whether not having the signature of witnesses will be fatal. That you can decide, like it has been decided for 47, 48. So here we have decided, but okay, we'll take up the decision on together with all these matters. So,
Lordship, kindly peruse section 62 of the BNS.
Same, my lord, all that it is.
what is 62?
Lordship, 62 is there, it specifically states that.
Has any Supreme Court judgment come on this? DK Basu is, of course,
Lordship.
legend.
My lord.
Legend.
36 and
Recent Supreme Court decision on the effect of non-compliance with 35(3), that there is no signature of witness. Kindly look up.
Lordship.
You look up, kindly look up, because of the, once we locate a Supreme Court decision,
Lordship.
like we are all students of law and officers of the court. So once the position of law laid down by Supreme Court becomes clear, then we get a clear direction,
Right.
whatever it is.
Otherwise also Lordship, 36(2) and 36(3) Lordship. 2 and 3 is their Lordship. In the Act itself, Lordship.
Yes, this is a general provision.
Lordship.
General provision. So you kindly look up if there's any, there's a recent decision,
My Lordship.
and on this point, that whether not having signature on the this is fatal, because DK bus was of course very long. That holds still, and we'll take up this
Lordship.
All of the section 25.
25.
25.
Mr. Bodal, learned counsel for the petitioner, and
Yes.
E. Sharma. And your good name, please? Learned counsel for the informant. Full stop. Learned counsel for the petitioner contends that he's seeking, in the subsequent bill petition, he's contending about non-compliance with the provision under section 35(3),
36 Lordship.
36 of
B.
the 36B of the
and 62,
BNSS,
and
in
62.
as much as the arrest memo pertaining to the petitioner does not bear the signature of any witnesses. Full stop. In support of the same, he has submitted a few decisions of coordinate bench of this court requiring granting bail in such a situation. The learned additional PP submits that some two other bail matters have been already fixed on Thursday this week to decide on the point of infirmity in the compliance with the arrest memo, but proper compliance with notices under 47, 48. Full stop. The learned counsel for the Mr. Manaf, learned counsel for the informant submits that in her statement during trial, in her deposition during trial, the minor victim has implicated the accused petitioner. Full stop. It is submitted by prosecution that out of 6 witnesses, 4 witnesses have already been examined. List the matter. Scan record is available. List the matter on 25th. See, the police administration will also be easier, because the IO will also be confused. Clear directions that
In most.
all these you follow all these. Now, more clear it will be, and less, it will be, people's rights will be feel more correctly. And if it is not compliant, non-compliant, that's a fact is fact. We should not run away from facts. Next time I'll follow. Repeating the same mistake again and again, that will not excusable. But otherwise, if I make a mistake, it's okay. Next time I'll follow it. But that should be the clear approach. No bluffing. On Thursday, we'll take up that, and kindly look up the Supreme Court position regarding that aspect.
I will try, Lordship.
Because if there are coordinate bench decisions, this becomes a principle almost. That if there's a compliance, if there's no compliance at 48, then even without witness's signature, it will do. Then it has to be, it becomes a principle. So it has to be resolved by division bench. Though the signature of witness has a separate purpose, and this has a separate purpose.
Lordship.
Actually, that's why I feel like that.
That is clear.
But anyway, but we cannot conflict on principle.
Lordship.
Facts we can conflict
Lordship.
sometimes, though ideally facts also should be same. But principle we cannot conflict. No?
Oblige, your Lordship.
Timing item 20.
I'm very sorry, my lord. My lord, I have some other court, my lord.
No problem.
My lord, oblige, my lord. It was called for, my lord, in this case.
Yes.
My lord, today CD not received, my lord.
70 BNS.
My lord.
70 BNS.
21.
70. 10-4 he is arrested. Get the case
My
diary
lord, I will try, my lord, on.
this week only,
Friday, my lord.
since we are
Friday.
closing.
Right.
Right. I would humbly suggest that don't keep too many matters for the last day.
Yes.
Try to keep,
Right,
we'll work long on last day, but new matters may come, no, suddenly, some urgency may come. Thursday is safer.
Yeah, only by one birthday.
Okay. The case diary is called for is not yet received. Issue reminder for the CD of Nunmati PS 55 of 20, list on 25. Nunmati should come.
Right.
Keep them, that's good.
Is my lords. So in this case, all the sections alleged are under 7 years, my lords. However, the mandatory notice under 35(3) was not served upon us and we were arrested. And we have been languishing behind bars for the past 40 days, my lords. It's a POCSO matter, charged under section 8 amongst others.
Notice has been issued, right?
My lords,
Notice
yes.
issued, notice not yet served, my lord.
Uh,
And CD also not received today, my lord.
My lords, may kindly call for the scan copies. And also the registry may be directed to place a track consignment report on the update of the.
No, they can also take instructions.
Of course, my
No,
lords.
they can take instructions.
And my lords, this
Scan
matter,
copy, no, we will get the original case diary.
Lord,
What do you
right.
say? Huh?
Right.
Original case diary.
and my lords, in this matter, I have instructions that the charge sheet has been filed
Okay.
and a sessions case has been registered, my lords.
Charge sheet submitted.
Yes.
Right.
Session special case number 198 of 2026. It's pending before additional district and session judge Rongia. And my lords, it's currently pending for production of accused and the next day is 24/6/2026.
For production of accused.
My lords, yes. Well, this is since this is a mandatory requirement, a constitutional violation. My lord, this is emergency in this matter.
No, if arrested without notice, then he has to, reasons have to be given.
Of course, my lord.
Ah.
And my lords, in light of the recent Supreme Court judgment, it has been said that 35(3) is a rule. And therefore, any infraction of the same has to be explained with.
That's true. Not sure.
If my lords may have it before the vacations, I'll be very obliged.
Yeah. Heard Mr. A. Burwa, learned counsel for the petitioner. And on the additional PP for the state. The case diary is not received. And it is submitted by learned additional PP that the notice upon the respond number 2/informant has also not been served. Issue reminder for the case diary of Rongia PS case number 116 of 2026.
But as per his statement, my lord, it has charge sheet
Yeah,
submitted.
just a minute. You cut it. It is submitted by Mr. Bora, learned counsel, that as per his instructions, the case has been, investigation is completed, resulting in a charge sheet. And special
Session special POCSO 198 of 2026.
has been registered and pending before the learned additional session judge, Rungia. The prosecution shall take instructions regarding the service upon the respondent. You get the service done. Get the service done. So what should we call? Scan copy
Scan-
or CD?
Scan copy of both, my lords.
Scan copy of prior court record along with.
In view of the aforesaid development, call for the scan TCR comprising case diary, charge sheet, and any other relevant documents. List of Friday before vacation on Friday.
Fine. 26.
26, my lords. Obliged, my lords.
May it please your lordship.
Yes, Mr.
If the petitioners are behind the bar for more than 1 year, 3 months. Charge sheet filed, your lordship, not a single prosecution
Your
notice has
lordship, may
been.
kindly peruse the earlier order, my lord. With regarding,
Scan record has been received
yes.
on 8/12.
Next date of the case is fixed on 3/7/26 for evidence. My lord, till now, victim not yet examined.
Just mention the dates, your
Is
lordship.
it POCSO? No,
No, yes. No, no.
No.
Not
POCSO is
POCSO.
not there. Earlier rejection order.
Page.
No, that is in the record, my lord. I
Record.
can copy of the record. Next date for evidence is fixed on, my lord, 3/7/26. Earlier rejection order of your lordship at case 38, my lord.
Acha, then, acha,
Lordship, may kindly tell me earlier order also, updated CD was called for, my lord. Second copy of PCR was called for along with the statement of the victim, my lord.
In this case, the charge was framed on 6th of August.
right, I remember. Allegations are a bit serious actually, so
Yes.
we could not grant bail. But anyway, the last date of rejection is in December 25 only. Victim has not yet been examined. How come?
Next date fixed on 3/7/26, my lord.
3/7.
Yes, sir. I have flag mark, my green flag mark in the record. For evidence.
Evidence of prosecution.
3/7.
Lordship, may kindly peruse the order from 22nd of January 2026.
22nd of January, the previous bail order. No, the,
This
from the
track order,
scan
yes,
record.
yeah, all 8 dates have gone by, not a single witness has appeared, your lordship.
Uh,
The
Lordship,
victim was forcefully pulled inside the bus, my lord. Thereafter, my lord,
Hmm?
in a running bus, my lord.
allegations are there, your lordship.
no, that's true.
Yes, but they are behind the bar, they have faced, during the investigation also, they were behind the bar.
22/1,
Yes, sir.
PWs are absent.
Then 16/2, your lordship absent.
Since 22/1, no witnesses examined.
Not singly, if since someone, your lordship, someone was first issued on 15/12/2025.
PWs are absent.
On last 8 occasions, your lordship.
It's true, actually. That is a matter of concern. No witness examined
Yes.
since 22nd January.
Earlier order of your lordship is also there for my lord expeditious disposal, my lord.
That is there, we are not denying, but not a single witness. has
That
been
order,
examined.
We can keep it pending and issue a direction.
Lordship has already passed a direction on 14/5/2026. Now, if the witnesses does not appear, your lordship, even after repeated.
No, then sometimes court is also helpless, but
Yes.
at best VWA can be issued. But we don't issue NVWA against the victim.
Whether they are further detained, lordship, they are very poor person, your lordship. I know the personal, their family condition. One is a driver and one is a handyman, your lordship. And they were arrested only on the basis of suspicion, your lordship. Even the charge sheet filed, your lordship, nothing is there, your lordship. And since lordship has passed an order that there should be an examination of witnesses, they were behind the bar, your lordship. And last 8 occasions, your lordship, not a single witness is turning up. 1 year and 4 months behind the bar, your lordship, during trial. The trial itself has become a punishment, your lordship, in this case. Very poor person, there is even no chance that they can tamper with that evidence at any stage, your lordship.
What do you say?
your lordship may kindly come to page 39, your lordship, regarding.
39 of?
Of the, my lord, petition, my lord, that is earlier rejection order.
That is, yes, that is lordship has.
Considering the gravity of the offense, yes, it
Man,
is
that is
not
true.
like other, my lord, 366, my lord, rape cases, my lord, here in a running bus, my lord. Those, the victim was forcefully pulled inside the bus, thereafter, my lord, from the running bus, she was pushed out, my lord.
I have myself state rightly or wrongly that this is a victim. Then we have to issue a phrase direction then. Should we keep it pending? Then instead of rejecting, we can keep it pending.
The witnesses are not turning up, your lordship.
So that we'll have to make a mention. Make a mention.
400 days behind the bar, your
Would
lordship.
them come after deposition of the, after recording the, my lord, statement of the victim?
No, that was.
Or should he, so it was rejected by this court earlier. You can approach the learned trial court also after examination of the victim. But no, it was rejected by this court. So the court, that learned court below may hesitate. Because bail was rejected by this court.
Case is that, your lordship, the petitioners are also wanting that the,
Otherwise, let them approach after
Yes,
examination.
Royal
of the victim,
Learned
my lord.
Counsel.
if the victim is not examined for last 8 occasions, your lordship,
Era
it cannot be
38.
examined.
No, okay, that is a legitimate grievance, no doubt.
Lordship may kindly
38, 39.
consider, your lordship. More than
Para
450 days behind.
1, 2, 3. See, no? 1, 2, 3, 4 negative post. It is fairly submitted at an earlier bail petition that this is a subsequent bail petition, as an earlier bail petition was rejected on 8/12/2025 in BA 3740 of 2025. The Learned Counsel submits that though charges have been framed, but
On 6/8/2025, your lordship.
on 6,
8/2025.
on 6/8/2025, but so far no prosecution witnesses have been examined, not a single.
Repeated notices.
How many witnesses are there in the charge sheet?
But you could find that chart sheet at page number.
Yes, I found the charge sheet.
Okay.
Wait.
Total 8 witnesses.
Eight witnesses.
Yes.
That should not be a problem. 8 witnesses are listed in the charge sheet. Full stop. Victim is not mentioned.
No.
Victim is not listed witness. 8 witnesses are listed in the charge sheet. Full stop. The scan TCR is available. Full stop. The learned counsel for the petitioner has drawn my attention to order dated 22/1/2025, 26.
26, Your Lord.
On which date no witnesses were present. Full stop. The subsequent orders also do not indicate examination of any presence and examination of any witnesses. Full stop. The next date is fixed on 3/7/2025, 26 for prosecution evidence. Stop. The learned additional PP has drawn attention to the earlier bail order, observing that earlier bail order and the observations therein. Full stop. The learned next paragraph. While the full stop. The petitioners were arrested on 2/4/2025 itself. One petitioner, right? Yeah. Two petitioners. The petitioners were arrested on 2/4/2025 itself. And as submitted by the learned counsel for the petitioner, they are aggrieved by the continued under trial detention, especially when prosecution evidence has not proceeded. Full stop. In the given, so should we keep it pending or? The bail petition is kept pending for the moment. However, the learned trial court is requested to do the needful for examination of the victim girl, whereafter a scanned copy of the deposition may be sent to this court, right?
Yes.
Sent to this court for adjudication of this bail. To stop. The scanned copy of depositions of any other witnesses examined in the meantime shall also be sent. Full stop. Copy of this order be sent to the learned trial court for the needful information and the needful. List the matter after vacation. We'll keep it pending.
On my lord, 28 of July.
No, Lordship.
If nothing is examined, then ultimately we'll have to.
On 14th,
Take a
Your
call.
Lordship, let it be on reopening, Your
14th
Lordship.
on the reopening again, my lord.
What purpose you will serve by keeping this person? Your Lordship, unless
It will be fair. Let it be on 15th or 16th, as per your choice.
16.
16th.
let it be on 15th, Your Lordship, 16 I may not be able.
15th, 7th.
Obliged.
15th, 7th.
Okay.
January 25.
Maybe. Something like that, something.
My lord, this is a second application, my lord. With all respect, my already in acceleration, my lord, anyway. Trying for survival. Here, what has happened, my lord? May I just place your lordship's rejection order? Here, as I have understood, reading the FIR, my lord, is a Kampura, my lord, and president of an IDGA committee, my lord. And thereafter, what has happened, my lord? For registration or some land deal, my lord, he demanded some, with all respect, my lord, the money, my lord. And the FIR is that, my lord, let me come to page 15 and 16, my lord, for the present application, my lord.
15 and 16.
15 and 16, my lord. Here regarding, my lord, there are a lot of, my lord, fracas between two groups of people, my lord. Several litigations, my lord. Those documents also we have annexed, my lord. And if I read page 15, my lord, the sum total is this, that, my lord, 2 plots of land, first, second, third, fourth, fifth, sixth, 10th line, my lord, belonging to Joina Bibi, my lord. There, my lord, he demanded, my lord, with all respect, my lord, 2 lakh in the name of withdrawal of objection. He objected, my lord. How much is paid, that is not there.
That is this is what is happening, you know, all these, moment
Yeah,
the
yes,
sale
sir.
transaction is done, there is an objection.
Yeah, yes, my lord, this has happened. My lord, this has happened, but how much money has been paid, it is not there, my lord. This instance, as I have understood. Second, my lord, from one Rukia Begum, my lord, there, my lord, total paid, my lord, 110, my lord, 80,000 in cash. That is, my lord, it can hardly be proved. And regarding 30,000, my lord, it has been explained, and your lordship's order also speaks of that, my lord. The quantum that is to be decided is 30,000. Whether it went into the account of the accused, who is a Gaon Bura, my lord, and he has been removed from service because of public complaint, 2 groups of public, my lord. Those documents we have annexed. The bone of contention is regarding this 30,000, as I have understood, my lord. And regarding this 30,000, it has been deposited to the Idgah committee that occurs at page, my lord, with all respect, my lord. 49, my lord. It begins at 49, several receipts, my lord. Now specifically page 51, my lord. Regarding this 30,000, as has been stated, my lord. 51, this is 5,000, and another, my lord, page 53, my lord, 25,000. Lordship may have seen, my lord. And regarding this, my lord, your lordship's order, possibly it tallies, my lord, only that is to be found out whether it went to his account. Without that, my lord, disposal would be possibly, my lord, with all respect, my lord, that is why I'm paying the lordship's rejection order, page 91. Therein, my lord. Para 8, my lord. Because that has to be decided. Whatever allegations, several allegations, my lord. 2 groups of people, I'll show documents also, my lord. Page 91, my lord.
Okay.
My lord, parting line of para 91, my lord. There is also a monetary transaction, but it is not fully clear as to whether it is into the account of the petitioner. Have I made my position clear, my lord? So, my lord, that aspect, if it is there in the diary, my lord, nothing to do, my lord. Other than specific, my lord, bank statement, my lord. If it went into his account, there is criminality, my lord. Otherwise, there may not be. And my lord, kindly see the other, I should not, I think, other document, 2 groups of people, even the lady whose land, who sought for mutation, objected to, there is a public petition against her that we have annexed, my lord. With all respect, my lord. Just for a reference, I'm placing it, my lord, with all respect, my lord. That occurs at page 71. Sorry, my lord, sorry. I'm taking a minute, my lord.
Okay.
Page 60, my lord, page 60. Number 5th name, the lady's name, my lord, whose land was about to be mutated, then there were objections, my lord. And kindly see another aspect that has come to my knowledge, my lord. Upon perusal of the documents, my lord, with all respect, my lord. Lordship would kindly have a look at Journal Bibir Matihini code, page 29, my lord. Kindly see. Here and there, something is there, my lord. 29. This is join of Bibi, my lord. Serial number 17, my lord.
I'll see it.
Page 29, my lord. Lordship has seen the name of join of Bibi, my lord. Thereafter, kindly see, my lord, it was mutated, or my lord, the partition case was decided way back in 24, page 41. Page 41. Sokrob, may I read it, my lord? অসমীয়াত আছে in vernacular.
Of course.
চক্ৰ বিষয়াৰ 22/8/24 তাৰিখৰ আপোচ বাটোৱাৰৰ নাম্বাৰ. Have I made my position clear, my lord?
Yes.
So this is in 24, my lord.
Mutual partition or mutual.
Exactly, my lord. Same DAG number, same thing, my lord.
I'll see it.
So, my lord, the only thing, my lord, FIR is in 25, my lord. And my lord, that amount 30,000, whether it went into the account of the Idgah committee or to the, my lord, online, and the cash, my lord, that will never be decided, it cannot be adjudicated, because there were two Idgah committees, my lord. Have I made my position clear? One says same Idgah committee, different parties, and my lord receives one resolution we have annexed that receipts cannot be used by anybody. One resolution says it can be used by everybody. So, my lord, only thing, my lord, when, my lord, partition case was decided in 24, FIR comes in 25, and regarding 30,000 rupees, your lordship's rejection order, with all respect and forbearance, my lord, as to whose account it went into, my
That has
lord,
been reflected.
that may be sought for, my lord.
They
Then
also- that was not clear at that time.
appropriate, my
Okay.
lord.
My lord, here we have received the case diary, my lord. First of all, Lordship was pleased to reject their petition only on 7/12/2025, my lord. It was already mentioned what the offense he has committed, my lord. And regarding, my lord, at present perhaps they have no new grounds. First of all, my lord. Thereafter, my lord, from the investigation, it reveals that, my lord, rupees 30,000, my lord. It was learned that 30,000 was paid to the below noted accused person online, which is alleged to be extorted money, and accordingly the payment screenshot it seized, my lord.
But anyway, so
My lord.
As to whose account it went into, my lord.
there's date of last rejection was in quite some time back then.
My lord.
There has been investigation after that.
After that, it was found, my lord.
The investigation has been done after that.
My lord. My
I
lord,
mean-
here what happened, my lord, the CD remains here, my lord, from 6/2026, my lord. In the order, my lord, it was retained, CD was full for retained, my lord. Then CD retained for 20 months, my lord. Here, my lord.
Informant. Anyway,
My lord.
you filed a affidavit. Okay, make your submission.
And regarding the witnesses, my lord,
After
Lordship
you
kindly
com-
peruse,
I'll-
my lord, here.
I'll go through it again. Sorry, ভালকে চাব লাগিব থৈ দিলে হ'ল আগৰখিনি আপুনি অলপ উঠাই দিব পাৰিব একচুৱেল পাৰ্টটো লৈ ল'ব তাৰ একচুৱেল পাৰ্টটো লৈ ল'ব বাকীখিনি আমি ভালকে অলপ চাব লাগিব You make your submissions.
Yes, just preliminary objection, my lords. My first submission will be, my lords, a second AB cannot be disguised as an appeal. All of this, what my learned senior counsel has submitted, it was all, my lords, it was held for in the last hearing, my lords, and your lordship gave a very reasoned and very finding, my lords. Now, my lords, may kindly come to in my affidavit in opposition, page 99, my lords. Now, my lords, may kindly note that this Gaoboya, he in a Singiba, in a village, he holds a position of power. Now, what he does, it's a modus operandi that has been noted in number of complaints that has been lodged before DC and before the police, my lord. What he does is that he identifies a person, a vulnerable woman, especially a old woman, and then he will go and he will say that, see, I am going to lodge a complaint if there is a deed happening, and since he is a Gaon boy and he comes to a knowledge of that, and then he goes and file a complaint, and on the basis of that complaint he extorts money.
What does he tell the old woman?
Old woman, man.
Old woman?
Old
That-
woman. He particularly.
Old woman was selling land.
Yeah.
Ah.
Yes, your lords.
Oh.
So, and this is not only one individual cases. There are number of people who have come across. Now, my lords will kindly come to page 99 of my affidavit in opposition. Now, we have also complained to the district commissioner. After we kindly come, if I may read the order, my lords. This is order of 2011 to 2025. At page 99 is the typed copy. May I read, my lords?
Yes.
Pursuant to the report submitted by the AC Hojai, so and so, along with so and so executive magistrate Hojai, by dated so and so, wherein it stated that an inquiry was conducted against the Gaonpoya of Singilpari under Kaspari Moza Sohit Muddin, that is the petitioner, pursuant to a complaint received from Liaquat Ali and 152 other residents of Singilpari so and so. The complainant alleged that so and so had initiated an illegal extortion racket targeting the common citizen of Singilpari revenue village, and that he had been extorting money by creating various issues such as land grabbing, manipulation of land records, and unauthorized dealing in government land. So this is a finding that has been come after DC conducts an inquiry through two executive magistrate, and then they put him on suspension. Now, I think when it's all of, after all of this submission, I don't think so. He deserves a second minutes, an AB minutes. And thirdly, my lords, I don't want to go into take much time of your lordship. What he has done against me is that he has again filed instead of as per his case, he is saying that the land of my mother belongs to him. Now, my lords, he should have preferred a civil suit. What he has done just to harass me and my mother, he has filed a complaint before an executive magistrate under 105 CRPC, which is 126 DNS. Now, my lords, we all know the law under 104 CRPC. A private dispute cannot be litigated and give a color of a public color and file for an attachment of that. So, my lords, it's an entire concentrated effort to abuse the process of law and to pressurize me. Well, it's just
Okay.
I've
I'll
also
I'll study it. properly. Yes.
Can I just record?
You can.
page 108 is the forms that he is submitting.
Can I just rebut him, my lord?
Okay, no
My lord, my lord, the Indian criminal justice delivery system is clear, my lord. Second application lies, my lord.
Lies.
When I file, that is my right. He is not to teach me the
We'll be
law.
on the same ground.
Secondly, my lord, that I have been suspended from our Gauhati ship, my lord, because we have annexed it, different groups of people, hence the issue. And the private dispute between parties, my lord, the bone of contention in the instant case, let there be hundreds of complaints, hundreds of cases, my lord. Each case has to be decided on its own merit, my lord. Here the bone of contention is 30,000. Lordship's earlier rejection order with all respect and folded hands, my lord. That, my lord, into whose account it went into, my lord. Because cash cannot be decided. That 30,000 part, if a detailed report is sought for, my lord, then there will be proper adjudication. This is my understanding of the matter, with all respect, my lord. And my character is bad, that I have been removed from Gauhati ship. General omnibus allegation, my lord, that's a different matter. And there are cases pending between the lady and this Gauhati. My general character is bad, does not affect my chances in the pre-arrest bail application, second application, which I am seeking, my lord. Only that thing is to be looked into with all respect and forbearance, that 30,000, if you went into the account of the Idgah committee, there is no case against me so far as this FIR is concerned.
Okay, I'll say that as well.
Things, my lords. With all due respect, my lords, I have, of course, second anticipatory bail is maintainable if there is a change of circumstances. But in there is no change of circumstances. With all due respect.
No, that you can submit, no problem. That has to be,
Second thing-
that is the
second-
point of adjudication, of course.
Just one thing, my lord, that he's a Gaon boya, so there is lot of land documents with him. That is still not been seized. So that is why his investigation.
That direction cannot be given, my lord, if something is not seized, that from Gauhati's possession, those documents should be seized.
And that's
That
for the
prayer cannot
investigating
be-
IO
should
to
not be
decide,
made.
but that can be an aspect of bail. Anyway, heard Mr. B.K. Mahajan, learned counsel for the petition. It is fairly submitted that an earlier bail application was rejected by this court
My lord.
on 17/12/2025 in AB 2880 of 2025. Mr. Mahajan, learned counsel submits that due to the venency of this case, the petitioner has already been suspended on the position of Gauhati, and that he's not in a position to influence investigation or manipulate documents, full stop. It is also submitted that referring to the earlier order, referring to the earlier order, it is submitted that has to be seen from the investigation as to whether the amount of 30,000 allegedly received by the petitioner had indeed come into the account, or whether it had come into any such amount had come into the account of the Idgah committee, in which case the petitioner cannot be implicated, full stop. The learned counsel submits and prays that the second subsequent bail application may be allowed. The learned additional PP has produced the case diary and submitted that there are no sufficient grounds in the subsequent petition for allowing the petition. The case diary has been placed before this court. Mr. Agarwal, D.K. Agarwal, learned counsel for the informant, draws attention of this court to the affidavit in opposition filed on behalf of the informant objecting to the grant of bail. Um, It is submitted that there are sufficient materials against the petitioner about being involved in the alleged offences. It is also submitted that in his past service as Gauhati, still some documents remain to be seized. Full stop. I perused the relevant materials, including the case diary, and considered the rival submission. I'll study it a little bit. Okay.
Idea of that, man. All right.
Today
All
only.
right.
Today only. It's the full stapler that we was ডাঙৰ এখন হলে ভালো আজি হৈ যাব হিয়াৰিং সৰিং হলে ডাঙৰ এখন লাগে তো just take a short break.
Fine.
So 26.
26.
May I please the lordship?
Yes.
For it here, we have not received the case, they are interim, my lord.
Just a minute. Yes, sir.
My lord,
Go ahead.
as per order dated 11/3/26,
Mhm.
I have already appeared within 7 days
Okay.
before the IO.
That's fine.
My statement has already been
Recorded. Okay. Okay. They'll get the case diary and
Up to date CD, my lord.
up to date CD.
Interim.
Interim will continue, of course. Mr. Saikia, Lord Counsel for the petitioner. B. Sharma, learned additional people, full stop. The learned counsel submits that pursuant to grant of interim bail, the petitioner is appeared before the IO and his statement has also been recorded.
My lord,
Interim was granted on 11/3, right?
11th.
11/3, on 11/3, full stop. The
Thank you.
case diary as called for has not yet been received.
I'll let
Issue-
see, my lord, up to date CD.
Okay,
But not. it's still-
Up to date case diary called for, not yet received. Issue reminder for the same, full stop. Interim bail by 11/3 stands extended till the next date of listing. You keep it after the vacation,
My lord, 22nd, my lord.
22/7.
My lord.
Highly appreciated.
22nd.
Yes.
Can be litigation, my lord. In this case, my lord, the opposite party has filed their no objection.
My lord, here we have not received the case diary today, my lord. Although service completed, my lord. But you may fix it after vacation, my lord. We'll produce the case diary, my lord.
Just a minute. POCSO case, you
POCSO.
filed no objection.
POCSO 6, my
No
lord.
objection. Right.
Not at this stage, my lord. Lord, you may call for CD, my lord. CD.
Yeah, just a minute, I'll just hear. Page 36. Yes.
Human years will take it
19 years later.
at present.
So if you want to, what we can do is if CD is necessary, then
My lord.
we can grant interim.
My lord, here, my lord, Lord, you may kindly press page 10, my lord. FIR, my lord. They have filed the FIR, my lord. Hereafter, they have again said that, my lord, they are misunderstanding, my lord. That truthfulness of the, my lord, regarding the offense, my
Might be
lord.
consensual also. We don't know. Because
Well, FIR actually was lodged
the
after
brother
many
goes
months.
have to remain undertaken.
Whatever may be, my lord, regarding the, my lord, instance of offenses, my lord, here, POCSO 6 is there.
It's pregnant also.
My lord.
Anyway,
How they ignore the, my lord, offense?
anyway, so how old is the accused?
Well, accused is, my lord,
Because that is always a relevant factor.
55
See,
years.
Huh?
55 years.
55 years. Oh,
Lord, you may
Then
call for
does
CD
not-
at this stage, my lord.
does not
That's
fit in.
interpretation if
Does
given,
not
my
fit in 55 years. She is 19 years.
At present 19, but at the time of the incident is minor, minor.
But I was just
At that time
trying to
also-
see whether it's some kind of
Minor.
love affair. So
Minor.
that aspect is ruled out.
Minor.
So can you get the CD before vacation?
On party and no.
That'll be no.
Just reopening, my lord, on, we'll put it on the 14th, my lord.
They are the neighbors. They are neighboring people. They are neighbors.
And DNA testing also done, my lord, that is also in the petition, my lord.
This is a subsequent bill petition.
My lord.
This is a subsequent bill petition.
Subsequent matter.
Oh, acha, acha.
Subsequent bill.
I see. Anyway, heard Mr. Chaudhary, and a good name, please, madam, your good name. D. Bora, Learned Counsel for the informant, and B. Sharma, Learned Additional PP, full stop.
It was
It is fair-
rejected on 15/10/25, my lord.
It is fairly submitted that this is subsequent bail application, and as an earlier bail petition was rejected on 15/10/2025.
My lord.
Full stop. Upon perusal of the case diary. Today, the updated case diary as called for is not yet received. However, it is submitted by Ms. Bora, the Learned Counsel, appearing on behalf of the informant victim, informant come victim, that an affidavit has been filed on their behalf, stating that the case was lost due to some misunderstanding, and that she does not object to the grant of bail. It is also stated that affidavit has been filed on her own consent without any coercion or duress. POCSO matter, no? So
My lord,
this
how-
is a mobile
How
phones.
they with that, these are the misunderstanding, my lord. What happened to the pregnancy, my lord? What you will explain, man, she will explain, my lord.
That is true. It is in the previous order.
My lord.
It is always necessary to write at this stage, but I missed writing this. It should be
Right.
written on this at this stage. But I did not write. I omitted to write that. This anyway, but we can always
14
see
minus.
see it.
14.
I'm only thinking whether he should be given interim or not.
I have the objection.
He should not have. Should not be given interim because
Minor.
he has
Earlier it was
she has
rejected.
appeared also. Age difference does not, it rules out any relationship. But
Yeah, earlier also rejected and 183 and when it was stated 183 implicated matter in the last order as part of order of this honorable court. Rejection order.
Well, actually, in the affair, actually, the allegation is said to have happened 3 months prior, and at that time, when the affair was, she was actually mature.
in the affidavit, the informant cum victim has indicated her age as 19 years. So, can you try for the case diary before the vacation? That is one option. The other option is to have it fixed after the vacation.
Pilot, 14th pilot. I prefer 14th pilot, 14th July.
Is it okay?
That's the interim protection.
Interim, I am.
Interim protection is given, my lord. Will appear before the police station, my lord.
Issue reminder for the case diary. Stop. The Learned Counsel prays for interim bail, which is objected to by the learned prosecution, learned additional PP. However, the Learned Counsel for the informant does not object to grant of interim bail. In view of the aforesaid developments as indicated above, within bracket, you write affidavit by informant and representation by Learned Counsel. Bracket close. It is directed that in the event of the arrest of the petitioner, connection with this case, allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction of the arresting authority and because, to the satisfaction of the arresting authority and subject to the condition that he shall cooperate with investigation, appear
Yes,
before the IO for recording his statement, and secondly, and not intimidate or harass or harm the informant slash victim in any manner. Violation will entail cancellation of bail. List the matter on.
Then matter 21, matter 22-0.
2-0. If a major states two different facts on two different affidavits, as a major, if I state two different things in two different affidavits, I may be liable for perjury also.
But
lying
type
on
of
note.
heinous offense, my lord, once they.
No, two
Yes.
different things. An
My
adult, how can you can prosecute a minor also, but not done usually, juvenile. But especially as an adult, if we say two different facts in two different affidavits, one of them is false, so that makes us liable for perjury. Actually. The perjury law is not very strong in India, unlike some Western countries, but it is still there. It does exist. Anyway, so adults always have to be very careful about what they state on affidavit. That is the purpose of affidavit actually, so that you speak the truth. Anyway, so let him be on interview.
28.
Matter. The step has been taken upon the informant.
You have taken,
Yes, but
not received.
probably not served a return.
Let's see what they say.
The address given in the FIR,
Hmm.
the same FIR mentioned in the application.
Okay, let us see what they say.
Kindly.
You have
Page 15.
received the diary.
My lord.
20.
It is, my lord.
It is received. Page 15 is the FIR.
Yes.
Zahar.
Manigula.
You want to read it?
My lord, we have received the case there, my lord.
Huh.
Regarding the service report, my lord, we have no any information, my lord.
Kindly take instructions.
My lord.
They will take the instructions. They will take the instructions.
My
Mr. Bora, learned counsel to the petitioner and Ms. Horma, learned additional people. The case diary has been received, but it's not clear as to whether the respond number 2 has been noticed, though steps have been taken. Full stop. The prosecution shall take instructions to the concerned police station about such service. You get the service done so that we can take it up. Case diary be retained. Let's take it up on Thursday.
Maybe given.
Thursday before vacation.
Friday.
Friday or Thursday?
My lord.
Okay, Friday.
26 minutes.
Oh, just a minute. No, no.
May I
It
please
appears in
In this case, my lord, 30, 31 and 32 lordship. My lord,
30,
FIR
31,
is my lord
32.
common lordship, some FIR lordship.
Earlier rejected by your
Yes, lordship. Right. Earlier it was my lord rejected by merely, not only merely, in addition to other grounds lordship.
Oh, so that's
As
no?
stage of investigation, kindly see page 41 lordship.
Yes, I've seen it.
Page 41 lordship,
Take two now.
paragraph 7 lordship,
Take two. Yes.
paragraph 7
I remember, Mr. Amit.
lordship, stage of investigation. It was on my lord rejected on 6/4/2026. After this, my lord, many things have happened, lordship. Now many progress is there, lordship. Already, my lord, 7 accused to my lord arrested, lordship, who have been, my lord, released by this honorable court on bail, lordship. Now 5 are yet in judicial
7 have been released. 7 have been
arrested.
released.
Yes, 7 arrested, lordship.
7 arrested, out of which some have been released.
My lord, out of which, my lord, 14, out of 14, 2 accused, my lord, are named in the affair. My lord. Other, my lord, who are actually involved in the case, they were arrested, my lord. 5 persons, lordship. They are not in the affair, lordship. My lord, they are in still judicial custody, lordship.
That's
Now, this honorable court granted 2 named accused, my lord, bail, my lord, regular bail, and another accused, lordship, accused number 3. Kindly see the affair. Affair is at page 11, lordship. Page 11, lordship. Now, first of all, kindly see the names of the accused, lordship, list of the accused, lordship, at page 12, lordship. List of the accused, lordship. Page 12, kindly see, lordship. Ames Ali, my lord, in petitioner in my lord, item 30. My lord, now Azizul was arrested. He was released on bail, lordship. Now, accused number 10, lordship. Accused number 10, Ahidur Rahman. Accused number 11, Zakir Hussain. And accused number my lord, 13,
Mhm.
13, or sorry, 14, my lord, in item number 31. Three accused are in item number 31, 10, 11.
Accused
and
number 14, Musharraf Hussain.
Yes, lordship.
11, Zakir Hussain and Ahidur Rahman
In item
and
31.
Azizul Haq. They are released on bail.
No, lordship.
They are in.
They are before you, lordship.
Okay, okay.
Now, accused number
I see. I get it now.
12 or 13, my lord, in petitioners in petition, my lord, item number 32, lordship.
Got
Now what happened, my lord? The cross case is there, lordship. In the cross case, my lord, the charge sheet is submitted against the other, my lord, accused in that case, lordship. Now this is one of the progress of investigation, lordship. In this case, my lord, the CD was called for in both the cases, lordship, and the certificate from the aims, my lord, where the unfortunately one person was, my lord, died, my lord, during the treatment, lordship, at aims, lordship.
Yes. Yes.
And this honorable court also called for the certificate from the aims.
But we
Probably it will be in the, my lord, case
But we
diary.
never got it, no?
Lord,
Earlier on occasion. We called, but we did not get it.
my lord,
Okay.
that's probably that will.
Let's see whether it has
that will
come.
be in the
I
case
remember.
diary.
I'm remembering now.
Now, my lord, in view of the charge sheet submitted, lordship, the accused, my lord, accused number 3, Tokdir Ali, my lord, has been granted, my lord, interim bail, lordship, by this honorable court. As this charge sheet has been submitted and prima facie, they are found involved in the case, my lord.
Charge sheet is submitted.
Yes, lordship, cross case.
Cross case.
Cross my lord. Case is, lordship, as regards, my lord, dispute of land, lordship. My lord, this, the honorable court, my lord, the coordinate bench, my lord. That observation at page, second page, my lord, third paragraph, lordship. Fourth paragraph. In the facts, sorry, second paragraph. Second page, second paragraph, my lordship. The learned counsel for the petitioner has submitted that cross FIR in respect of the same incident was registered as Dolgao PS case number 47 of 2010, in which charge sheet has recently been submitted. The fact that the charge sheet has been laid in Dolgao PS case number 47 has also been confirmed by the learned PP. You know, the interim bail was granted. He is in interim. He, my lord, has been cooperating with the, my lord, IU lordship. Now that case, bail petition is still pending for final disposal, lordship. Now, the petitioners in this case, my lord, they, my lord, are before you, lordship. No interim is granted by you as the second petition is there, lordship. Overall, for consideration of, my lord, case that in that case was, my lord, in my humble submission, lordship, this is my lord, important progress of investigation that they are found, my lord, involved in this case. Prima facie, my lord, case is established against, my lord, other party, lordship. This is a case, lordship, my lord, there are ropes quarrel, lordship, between two parties, plaintiff and defendants, lordship. In item number 30, my lord, petitioner is the son of the plaintiff. My lord, other son who was actually in the, my lord, place, lordship, he was arrested, Azizur Rahman, lordship. And he has been released on bail, lordship. Now, I have, my lord, other 5 persons who are not in the FIR, lordship, they are actually involved, and the IU has, my lord, arrested them, lordship.
They are in custody.
My lord, the petitioner's name have been, my lord, implicated in on some conspiracy, lordship. What I am submitting, lordship, after rejection of the, my lord, 2/4/2026, lordship, there may be many, my lord, progress in investigation. My lord, other witnesses might have been, my lord,
Surely, I
my
will
lord,
see.
interrogated, lordship. In my humble submission, my lord, if the IU has, my lord, fairly investigated this, my lord, the petitioners would be found, my lord, not involved in this case, lordship. So, for, my lord, overall conviction, kindly see the, my lord, your lordship, earlier your lordship retained the case diary, my lord, that Perry used, lordship. And on the basis of, my lord, post-mortem, lordship, there are found some, my lord, injuries upon the, my lord, person who had unfortunately died, lordship, from that part, lordship, that side, lordship. And on that ground, and my lord, stage of investigation, my lord, petition was rejected, lordship. Now at this stage, lordship.
Let me
What,
come.
My lord, earlier your lordship was pleased to reject
Yeah,
the bail petition.
that I've
of the
seen,
present
yes,
petitioner, except one person, my lord, one, my lord, in item number.
There's progress of investigation.
Yes,
I'm
yes,
sure.
my lord. Nazmul Haq earlier not rejected for the in item number 32, my lord.
Mm.
And as per postmortem report, my lord, cause of death is coma as a result of head injury. And total 11 injuries earlier also my lord pointed out. And regarding my lord, the involvement also your lordship earlier order rejection order is available in the case diary. And regarding the present new accused person, my lord, his name is also my lord stated by the complainant. He was the Gaubura, my lord. Admittedly, land dispute is there between the parties, and because of that land dispute, my lord, that dispute occurred, and ultimately, all these accused persons were in a group, my lord, attacked, and thereafter, my lord, killed one person, Jamil.
They are also implicated,
One statement of the
these
complainant.
persons, except that,
Nazrul Haq, my lord.
because his submission is that if it is his instruction is that they are not the culprits, they have been roped in. Anyway,
But
that is his instruction.
earlier also because state witnesses.
What is the, it was last rejected on 6/4/20, that is
6/4/20.
about 2.5 months,
Then, my
right?
lord,
So kindly see the progress of that.
Progress, my lord, investigation, my lord, substantially otherwise progressed, my lord. Considering the, my lord, some of the 7 accused persons already arrested, and my lord, 7 out of and the police is in charge of these these accused persons, my lord. Otherwise, they are fleeing from justice now, my lord. Otherwise, from the
It has progressed.
PM report and other materials,
You can submit.
my lord, my humble submission has already accused number 3, my lord, is protected lordship. We will also appear, my lord, the investigation.
Accused number 3 of this case, not the cross case, this case.
This case, lordship, accused number 3, lordship, is completely lordship, and it's case 11.
He's got prayers bail
Yes, lordship.
from
Coordinate,
coordinate bench. Do you have the order?
my lord, I have submitted the orders.
It's okay, no problem. Yeah,
My
please.
lord,
my lord,
on
DNA
the,
report.
on the ground of my lord,
DNA
submission of
profiling
charges,
request.
lordship.
That report, my
Tell
lord,
me.
for what purpose?
No, sorry.
Those reports not yet. For what purpose, my lord, DNA profiling?
Earlier, lordship, IU submitted objection, lordship, and that was also considered, lordship. Now, probably today, my lord, IU has not submitted. There may be some note from the IU, lordship. My lord, there may be some note, lordship, from the IU, lordship. That also.
Yeah,
may
you can say
consider,
whatever.
lordship.
I've heard you earlier, but
Yes, lordship.
last round,
But,
lot of dispute between the two parties.
Yes.
Land dispute.
Yeah, lordship. In such a case, my lord,
there are only things that my lord in the cross case, my lord, charge sheet has been laid.
Mhm.
And my lord, the finding of charge sheet in another case.
Mhm.
So, and then
That may not be.
the accused person, they are not involved in killing. My lord. My father was killed, my in a not the planned manner in a group, wise my lord, they attacked us. And several injuries of our family members, my lord, that also may be considered, my lord. And-
According to your instruction, all the these petitioners also involved?
Yes, my lord, and mainly my lord, Nozmu, who happens to be a Gaugura, my lord, he was the leading person, my lord, he, my lord, led the move, my lord, towards our house, my lord.
Motive is
And
clear,
my
my lord,
lord,
because of that land
He
dispute.
is using his, my lord, official capacity into, my lord, grazing land, my lord, they are intending to. graze
Is the
our land.
petitioner in?
He is the petitioner in item number 32, lordship.
Sole petitioner.
My lord. Oh, yes, lord. Now, what I am submitting against my main conspiracy against my made against this person, lordship. He is my target, lordship, in this case, lordship. My lord, the fact is, my lord, the quarrel is between the plaintiff and the my lord defendant's, lordship. Accused petitioner nam Amez Ali, lordship. He is the son of the plaintiff, lordship. My lord, we are other petitioners are not related, lordship. So, my lord, we will cooperate with the investigation, my lord. On the other, provocation is, my lord, prima facie established, my lord, during the investigation. My charge sheet is submitted, lordship. My lord, this is a severe, my lord, quarrel, my lord, as regards possession of land, lordship. My lord, for provocation, there, we admit there was, my lord, quarrel, lordship. In such a case, my lord, the petitioner
Anyway,
may be given liberty to appear, my lord, they will.
M.H. Ahmed, learned counsel for the petitioner. P. Botakur, learned additional PP, and Mr. Learned counsel for the informant side. ML for the first time. Agar order to apni para 2-3 lo labo. Para 2 to lo labo. First of the gist of the allegations in FIR is is assault by a group of persons leading to injuries and death of one person. Full stop. Death of the father of the informant. Full stop. It appears that a cross case was also registered in connection with the incident, being Dolgaon PS case number 47 of 2026. Mr. Amit, learned counsel for the petitioner, submits that earlier bail petition was rejected on 6/4/2026 in AB 591 of 2026. And in the intervening period till date, there might have been further progress in investigation and seeks bail at this stage. It is submitting a copy of the relevant order. It is submitted that Taqdeer Ali, accused in the cross case, was granted pre-arrest bail by this court on 2/6/2026 in AB 875 of 2026 in the context of completion of investigation of the case. Full stop. It is fairly submitted by the learned additional PP that there has been substantial progress in the investigation, though the same is not completed. Mr. Ali, learned counsel for the informant, submits that the informant side opposes the grant of bail as the incident took place in a pre-planned manner, and the informant's father was killed in the incident. Full stop. The case diary has been placed before this court. To be common order, I think. Considering there's no doubt that the nature of the allegations is of serious nature, though the learned counsel for the petitioner also contends that the present petitioners have been roped in, and that the main accused persons have already been arrested and are in custody. Full stop. Considering the progress of investigation and the fact that the present petitioners have not been arrested so far, arrested till date. Full stop. I'm of the considered view that perhaps the remaining investigation may not be compromised if they are granted bail at this stage, subject to suitable conditions. Full stop. In such view of the matter, it is directed that in the event of arrest of the petitioners in connection with this case, they shall be allowed to go on bail of rupees 50,000 each, with a surety of the like amount each, to the satisfaction of the arresting authority. Full stop. However, the following conditions are imposed. Number one, they shall cooperate with the remaining investigation and shall appear before the IO for recording their statement. They shall not hamper or tamper with evidence. They shall not in any manner harass, harm, or intimidate the informant side, or try to influence any witnesses. Violation of the bail conditions will entail cancellation of the bail. Return the case diary. Bail petition stands disposed.
Absolutely.
So, same order, huh? Silo. Repeat kori ba okay. Eta na lage.
Wait, detail.
33, my lord, petitioner is in interim, my lord, CD not received.
We'll wait.
Interim may continue.
Mr. Lashkar and P. Bortaku, full stop. The case diary is not yet received. Full stop. The petitioner was granted interim bail on 18/5/2026. He must have appeared or might have appeared.
Yes, appeared.
It is submitted that pursuant thereof, the petitioner is appeared before the IO and his statement has been recorded.
Lordship, here he appeared before the IO, but the IO asked him to appear on 6th of June.
Oh, I see. Okay.
That is why.
He appeared for the, before the IO. But he was asked to appear again on 6th of June. Statement or not? Issue reminder for the case diary. Full stop. The interim bill dated 18/5 stands extended till the next date of listing. 22nd.
Oh, yes, 22nd of July.
Deeply obliged.
It needed line. Bill hearing of authority.
34 short sheet
Line.
submitted.
Oh, proceedings. Yes.
Before going to the case, my lord, here my lord, altogether, 8 petitioner filed this bail applications, my lord. Out of 8, my lord, 4 petitioner has already surrendered before the court, my lord.
Okay.
Petitioner number 2, 4, 6, and 7, my lord. And thereafter.
They got bail?
And they are gone on bail, my lord. And.
Actually, this,
But other, my lord, still, my lord, not arrested or surrendered, my lord.
probably I mean, I don't make issues of
And,
these things, but the thing is that the learned court below probably was not aware that bail petition is pending
My
here.
lord, maybe, my lord.
Otherwise, my lord,
Otherwise,
during
they would have
pendency of
asked
the, my
you
lord,
to wait or something.
And.
during pendency of this bail petition, my lord.
Hmm. Because the granting of the regular bail, this makes this infructuous to the extent of these 4 persons. Anyway,
And so far the development is concerned, my lord, today morning I have taken instructions, my lord, already it has been submitted and PRC case has been registered, my lord.
Yes. Short sheet submitted.
So this is the issue, your lordship.
that is your instruction also, charge sheet
Yes,
submitted.
yes, short sheet submitted. On
This year is
29,
called
short
for-
sheet submitted on 29/4/26.
So they will also appear before the learned court. They can also appear.
Protection may be given.
No,
Only till then, my lord, till the date of.
they can appear and seek bail.
Yes, my lord.
The others
Till
have been
then,
given.
protected, my lord. Petitioner 2, 4, 6, and 7 has already been put them in trouble. Other is my lord.
The 8 petitioners herein had invoked the provisions of section 482 BNSS to seek pre-arrest bail in connection with Dhula PS case number 127 of 2025 under section so and so. Full stop. The gist of the allegations in the FIR dated 15/11/2025 is about assault and causing of injuries. Full stop. As many as 12 accused persons are named in FIR. Full stop. The case has already been charged sheeted by CS number 51 of 2026 dated 29/4/2026, comma, as reflected in the previous order dated 3/6/2026. The learned additional PP confirms the completion of investigation. Full stop. The learned counsel for the petitioner submits that in the meantime, petitioner number 2, 4, 6, and 7, namely, dash surrendered before the learned court below and sought bail pursuant to which they were allowed to go on bail. Full stop. Stop. In view of the same, full stop. No, in view of the same, full stop. In the context of completion of investigation and the aforesaid development pertaining to four of the petitioners hearing dash. This petition is disposed of with the observation that the petitioners shall appear before the learned court below and seek regular bail, which needless to say, appear before the learned court below and seek regular bail, and necessary orders shall be passed thereon. Keeping in mind the aspect of completion of investigation and also aspect of clarity. a copy of this order shall be placed by the petitioners, the remaining petitioners before the learned court below. That should suffice. That should suffice.
Till the protection may be given till the appearance, my lord.
That's the till their appearance before the learned court below, the remaining petitioners herein, namely so and so, shall not be subjected to coercive action. That's all.
No, within how many time? 10 days.
I have not given time frame, but you apply, appear as soon as possible and give a copy there. Please first. আমি order should যাও what আছে just like civil criminal mixed আছে দিয়ে দিবেন
Please, Lordship, I may be granted a week's time, my lord, to take steps upon the newly substituted respondents, my lord.
Okay, you're for the petitioner.
I am for the petitioner, my lord. On the last occasion, the legal heirs were substituted, my lord.
Yes. Learned counsel, good name please.
A decam.
A Deka learned counsel for the revision petitioner submits that on the last occasion only the legal LRs of respond number, deceased respond number 1 were substituted and he seeks some time to take steps upon the said substituted LRs. Prayer is allowed. List after vacation.
Yes, please.
Shall we fix a date or automatic? List,
4 weeks.
list after 4 weeks on a date to be fixed by registry.
Public.
Yes.
Your Lordship, in this transfer petition, the petitioner and respondents are both husband and wife.
Okay.
And their marriage was solemnized on 5/11/2013.
Hmm.
Due to atrocities committed by respondent and her family, so
She has filed
the
a-
petitioner was forced to leave and.
File a divorce matter.
Yes,
She is seeking, right?
yes,
She is seeking a transfer.
yes. From Udalguri to Gauhati.
She stays in Gauhati.
Yes, she stays.
What is the stage of the case now? Oh yeah, there's
On the trial court, it was on stage at evidence on affidavit by the petitioner, and it was next date on 16/7/2026.
respondent notice has not been served.
Yes, sir, but
As per office note, then you can serve again. You can serve Dusty also if you want. Neither ID card nor unserved notice.
yes,
has come back. Process servers report. So would you like to serve Dusty by hand? You can file an affidavit. There's a matrimonial man, their husband might. So there might be some,
yeah, we can serve the notice, but stay may be granted for further proceedings.
Mr. Thakuria.
No, I am appearing on behalf of Mr. P. Thakuria.
no,
I'm
you're good.
H. Bora.
Age for
Yes.
learned counsel for the petitioner. Full stop. The petitioner stated to be the wife is seeking transfer of PSD 35 or 25 from the court of the learned district judge Udalguri to the court of the principal judge family court Kamrup M and Gauhati due to her inconvenience. Full stop. It is stated that she was married with the respondent and due to some atrocities, she had to leave the matrimonial home and the strain in the relationship ultimately led to filing of the divorce proceeding. Full stop. As per the office note, the service is not complete upon respond number or upon the respondent. Full stop. You take fresh steps. You take a fresh steps. the petitioner side shall by Dusty or speed post.
Speed post.
Both you can take.
Both.
The petitioner's side shall take fresh steps upon the respondent by speed post. Full stop. The petitioner is also at liberty to resort to Dusty service, in which case compliance affidavit shall be filed. File a compliance affidavit, right?
Yes.
Full stop. I've considered the prayer of the learned counsel for stay till the returnable date. Full stop. You will not be prejudiced actually. Will you be prejudiced? You want it to be stayed till the next date?
Or further proceedings of the trial court.
Won't be prejudiced so much. Then please take the steps quickly, huh?
Okay,
So that
Your
this should be disposed of,
Yes,
isn't
Your
it? Otherwise, everything will get. She has filed the divorce, right?
Yes.
She has filed the divorce, so it will get. She has filed the divorce, I think.
No, actually it's a husband.
Husband has filed the divorce. But I mean, to language all change code like that. Husband has filed the divorce. Okay. Upon giving my consideration to the matter, it is directed that further proceedings in TSD 3525 pending before learned DJ Udalguri shall remain stayed till the next date of listing of this transfer proceeding.
Highly obliged, Lordship.
List after the vacation on, let us give a date. 27/7, right? 27/7. Scan TCR is available. Once they appear, we can dispose this off because scan TCR is also available.
Party. Highly obliged. May I please, Your Lordship? This matter will be taken up for final disposal, Your Lordship, today itself. My brother must be appeared for respondent number 2 and notice of respondent number 1 has been served. I have filed a petition on 11/11/25. My evidence was closed in MSCT Barpeta.
Achha.
On 21, my right leg was amputated, Lordship. I want to introduce that only that part of documents, and that was rejected.
So you
That's
could
why-
not appear.
No,
No.
I have appeared.
Uh-huh.
And I have adduced evidence. I was cross-examined discharge.
Uh-huh.
During pendency of the trial, my leg was amputated.
Okay.
The injured leg was amputated. And I want to adduce those part of documents.
Additional evidence.
Yes, additional evidence. That was rejected, Lordship. Impugned order is at page 17, Lordship, at page 19. I have a limited prayer only.
You
I
have
may be
appeared
allowed
for
to-
the insurance company.
I may be allowed to reduce the, only this part, new part of the.
Hello, as far as the order is concerned, my lord, Lordship may kindly see, there are three, my lord.
Which page?
There's page 19.
19.
The order has been passed on the basis of the factual aspects placed before the learned member, my lord.
Right.
So in that
Barpeta,
case, my lord, the lordship might record the case record because there is also prayer for calling the case record. Because the evidence was closed, my lord.
Let me see.
Yes, my lord.
You want me to just, you can take me through the order also.
Yes,
If you want.
countering the submission.
Learned counsel for the and pressing. What is the stage of the case otherwise?
DW.
DW. It has started.
At the stage of DW, they filed the petition.
Oh, okay. DW has not started.
Not now. On the very first day, this petition was filed.
I have acknowledged my medical documents also, Lordship,
Mhm.
here at page 15.
So the medical documents were up to 1922, my lord. The order
No,
reflects, my
the
lord.
latest.
The additional evidence on affidavit has also been filed, but by this application, you want to file additional documents.
Yes, Lord.
The documents by way of affidavit only.
That-
It will be the second affidavit,
Second affidavit.
second additional affidavit.
Additional affidavit has been filed, my lord,
Yes.
subsequently. Once
But he want, no, these documents, if this has to be allowed and brought in, it has to be, it should be by through an affidavit. Better through an additional affidavit, a second additional affidavit, isn't it?
You will be again re-examined, my lord.
Examine, yes.
Now, my lord, my point is that, my lord, the order reflects itself
Mhm.
that there is
Some
no-
factual aspects.
Yes, yes. Because since after 1922,
Mhm.
and the petition is filed in the year 2025, my lord,
Mhm.
on 11/11/25.
That is why actually because otherwise.
There is no document.
Mm,
There is no document. Even at the additional affidavit also, there is no mention of such any further treatment. The order reflects itself.
But amputation would be a matter, it would be a
Page
fact,
15 is there, Lord.
isn't it? Amputation to it is.
Page 15, go to the page 15, Lord. It is a certificate of Midland Hospital, Gauhati.
Yes, it is there, my lord, but it is after 3 years, my lord,
That is there, there's some
Recording
delay
of
on his
record
part.
of-
actually.
My injury is on the right leg.
of last treatment, my lord.
They will get ample opportunity to cross-examine to discredit this document if they want. They may challenge this document during my cross-examination.
Midland Hospital, right? Not James. Okay, I think we can take that.
Submission may be recorded.
Yes. So heard, Mr. S.K. Poddar, Learned Counsel, petitioner and Learned Counsel for, there are no other respondents in this petition, CRP?
No, one note has been served, Lord, as per office note. Tracking report.
Okay. Full stop. It is pointed out that as per the tracking and delivery report, the notice upon respondent number 1, owner, has already been served.
Owner
Served.
cum driver.
Owner cum driver is already served. Full stop. The instant application has been filed under section Article 227 of the Constitution of India, read with 151 of the CPC 1908, agreed by order dated 17/12/2025, passed by the learned member MACT Borpeta in MAC case number 438 of 2022, whereby the prayer of the petitioner, prayer of the claimant petitioner to adduce additional evidence within bracket, right petition number, PN number 5135 or 25 was rejected. Full stop. It is submitted by Mr. Poddar, Learned Counsel for the claimant petitioner, submits that due to the injuries sustained subsequently, the petition, the claimant's right leg was amputated below the knee, and he wants to adduce documents pertaining to the same by way of additional evidence, full stop, which however was not allowed by the learned tribunal, full stop. This court has been taken to the relevant order, impugned order dated 17/12/25, and also the copy of the petition which was filed to adduce such additional evidence. Full stop. It is stated in the petition, in the revision petition, that the right leg of the petitioner claimant was amputated on 25/11/2025 at Midland Hospital, Gauhati. Full stop. Whereafter he is suffering from permanent disability. Full stop. The Learned Counsel for respond number 2/insurance company submits that certain factual aspects has been mentioned in the impugned order, and in the context of the same, whether the records may be necessary for adjudication of the same, or adjudication of the present revision petition. Full stop. However, the Learned Counsel for the claimant petitioner submits that on the basis of the available, basis of the materials available with the court at this stage, the matter can perhaps be disposed of. I perused the relevant materials and considered the rival submissions, full stop. In the context of the amputation stated to have been undergone, amputation of his right leg stated to have been undergone by the claimant, though there is some delay in adducing evidence on his part during the claim proceedings, as noticed by the learned tribunal, it would be fair and just to allow him to bring on record the necessary documents pertaining to such amputation of his right leg, which is undoubtedly a serious matter. Full stop. In such view of the matter, the impugn order dated so and so is hereby set aside, and the petitioner as claimant may be allowed to adduce additional evidence and incorporating the documents pertaining to the aforesaid medical development regarding amputation in the interest of fair, just and complete adjudication of the claim proceeding. I'm not, since he has undergone imputation, so I'm not imposing cost. It's okay, no problem. There's an interim order, it merges.
Yes, sir.
What is the interim order? Stay of proceedings.
A date may be set for appearing of both the parties, but we may appear according.
Interim order was passed for stay of further proceedings in the claim case. The interim order is vacated and the claim case may now proceed. The claimant petitioner shall appear before it is submitted by both sides that the case is reached the stage of respondent evidence, which however has not yet begun. The claimant petitioner shall appear before the learned tribunal on, you can say,
Maybe 13th or 14th of July.
14th of July, 14/7.
Before MSC sector.
MSC about it. Civil revision stands allowed and disposed for terms.
Deeply obliged.
Lordship,
Just move.
I beg to item number 47, my lord.
47.
Yes, my lord, I regretfully inform you, your lordship, that the appellant has committed suicide, my lord, today, my lord.
Oh,
He was detained in Nalbari jail, my lord, from the date of judgment, my lord.
okay. So
So
there only he committed suicide in the jail only.
inside the jail, my
Oh.
lord,
There has to be
because
there'll be,
IO was pending and
now some inquiry has to be done actually. They will do
has to
it.
be done, and that certificate must have to place before this court by the authority, my lord.
Okay. So we'll adjourn it. Because we come-
That certificate may be called for, my lord.
Ms. S.K. Nargis Land Council
For the registry.
for the appellant submits that in the meantime, unfortunately, the convict appellant has committed suicide inside jail premises. Anything on your part? And praise that jail report may be called for, the death report may be called for from the concerned jail authority.
For the registry, man.
To the registry, the prayer is allowed. Stop.
First week of August.
The registry may procure the death certificate of the convict appellant for further orders in this proceeding. After, what did you say? After,
First week of August, my lord, or after vacation, my lord. After vacation.
let it be on
27.
31/7.
Fine.
31/7.
Obliged to it.
He was convicted for what offense?
Under 21B for 7 years. Though I made mention before the court, my lord, it was not listed.
Drugs, some because they have some other problems also, no? Mental problems, along with drugs.
Obliged lordship.
Sorry to mention at this stage. But actually, I am praying for listing of a criminal petition along with item number 6, which is listed as item number 6 as a part of matters, lordship. That was challenged an affair, lordship, quashing of affair. And the matter is fixed on 15/7, lordship.
Okay,
Out of the same affair, lordship, we have also.
which matter?
Item number 6.
Item number 6. Okay.
Adjourned, lordship.
This was adjourned.
Yes, lordship. So, lordship, I am praying for listing of the case along with that matter on 15th July. lordship.
Oh.
Highly appreciated.
Item number 41. Yeah, please, Your Lordship. This is appeal against conviction minor. As per office note 225/26 minor, answered notice. It's a 376. May I appoint amicus curiae minor? They are not turning off minor.
Notice is served,
Not
Answered,
served,
my
my
lord.
lord. Served notice.
Answered notice minor.
unserved notice, POXO matter.
This is 376 minor.
I see. Not essential, respondent is not essential, but since you have implemented and served,
Yes, yes.
tried notice. So
What's my place in amicus curiae after and
what do you say?
matter fixed for
My lord,
after vacation. minor.
as per office note, my lord, that is answered notice.
Unserved.
I'll notice of this with my.
Long back minor.
Hmm.
Because of that address minor.
Address could not be located.
Yes, madam. They have changed the address. I think, madam. They cannot track the respondent, madam.
Because usually, I mean, we can appoint, but usually it is after notice and nobody appears.
And sometimes they also appear.
Sometimes they also appear. So you guide me what to do. He is suggesting, of course, to appear in an appointment at my amicus.
They have,
But in such cases, it is not essential to implement.
Yes, ma'am.
What you have implemented, as I said,
application already filed, madam, by the learned PP, madam.
is already filed.
This is
now.
10 years.
10
that's
years
why,
only.
Mr. Bora, learned counsel for the appellant, convict appellant, full stop. He is in jail.
He's in jail, madam.
Notice upon respond number
Two.
2 has returned back unserved due to, as the address could not be located.
Right.
Full stop. Full stop. Refer, comma, as per office note dated 22/5/2026. So what should we do? Fresh steps or?
Fresh steps.
Hmm?
Fresh steps.
But they have already changed the place, madam.
Do you know,
Yes.
you can try once,
My lord, once.
you can try to get the latest
My lord.
location since you have implemented
Madam.
and try to, and take fresh steps, that's all. And thereafter, if you are unsuccessful, then
Then can it be, madam?
we'll not bother, then
Marvelous.
we can appoint an amicus.
Can be on 15th then, madam, after vacation.
The appellant side shall try to locate the new address, the up-to-date address, up-to-date / current address of the respond number 2 and take fresh steps
Madam.
by speed post.
Speed post.
My.
Speed post through
It
the,
will be easier for tracking my lord.
through the registry
Through registry.
Not necessary.
and concerned police station, no.
Through
Consult.
registry, madam.
My lord.
Steps may be taken to the office of the PP
PP.
and to be executed by the concerned police station. Whereafter, the prosecution is at liberty to take instructions regarding such service. Full stop. The original TCR is already available. Full stop. The appeal was admitted on 9/2/2026. It is submitted that they have filed an objection in the IA. In the IA. The appellant is stated to be in custody at present, serving out the sentence. Full stop. List on 15/7.
15th.
Anything to be passed in the IA?
No.
No, madam.
Not necessary.
Not this one. We'll press it after. Obliged, madam. 42.
Lordship, may kindly pay last order, my lord.
Hmm.
13.5, my lord.
Yes, Lordship, this honorable court has asked us to find the track consignment.
Track, could you find?
In the postal website, due to some technical issue, we couldn't find the tracking
Okay.
code. So Lordship may allow us,
Yeah,
we'll take fresh steps.
yeah, fresh steps you want to take.
Yes, Lordship, but
Yes.
only prayer is that Lordship, if Lordship allows, then if the case is stayed till the next returnable day, Lordship. So Lordship may kindly appreciate the FIR, Lordship, with that page number 40, Lordship.
FIR,
Yes,
you're
Lordship.
quashing off proceedings or FIR?
Proceeding,
My lord.
entire proceeding FIR charge sheet.
Notice, my lord, you will have to take
The,
fresh step.
Lordship may kindly appreciate the petitioners are professors of a college, Lordship. In the FIR, there is not an iota of allegation against the professors, Lordship. It was lodged by the principal of the college. Alleging
Volume
some
of PS case number.
forgery in
What
the
is,
mark-
what is the stage of the case?
It is in the appearance stage, Lordship.
Appearance,
What-
charge sheet submitted.
Charge sheet already submitted, Lordship. Proceeding is ongoing, Lordship. Next date is.
And they are on bail, right?
Bill, my lord, they are on bill.
And I think it's. We
My
can,
lord, এটা motion on that motion, the proceeding not state, my lord.
acha.
On last occasion, although not recorded.
The
in the order-
subsequent orders, my lord, notice issued, my lord.
Okay.
And let them appear, my lord, thereafter, Lordship may consider their prayer, my lord.
The last occasion, this honorable court had verbally considered, so.
No, they had appeared, they are on bail, he says.
Bill, my lord, they are on bill, my lord.
Oh.
But proceeding is
Okay.
ongoing.
You can appear.
Yeah.
My lord.
You will not be prejudiced, I think.
I know.
Since you are on bail.
It's a prejudice to them. That regularly
that's
they
okay.
appear also. Till next day, if.
We'll examine it.
I know.
You. What is the allegation? FIR?
Allegation is Lordship, National Paris page 40, Lordship.
Let's have a look. This petition is filed by two. Two persons, Vidyut Vikas Bose and Dr. Mokibur Rahman.
Principal made allegations in the FIR that there has been some scam related to forgery of mark sheet ongoing.
Just a minute.
He named some students of the college, Lordship.
One of our students.
Ironically, Lordship, even in the subsequent stage, not in a single occasion, anything incriminating was seized from the petitioner's possession. But surprisingly, in the charge sheet, suddenly their name came up and the police did not give any reason why they were implicated, and the persons whom were alleged in the affair, they were removed from the charge sheet entirely. There are other materials.
This person is, only this person is named in the FIR, no? Noyon, something, Noyon.
Noyon and one Sachin Sahani, they are students, Lordship. So. Lordship,
And can I have a look at the charge sheet since you are
Lordship,
praying for
charge
stay?
sheet- charge sheet, page number. It starts from page number 82, Lordship.
80?
82, Lordship.
82. Earlier format.
Lordship, you see the second column, Lordship, where in the last column, police has said for the upgrade for really removal of the actual accused persons from the trial and included these two petitioners in the charge. Lordship, may allow.
Noyon, he was not sent up for trial.
Not in, no,
He
Lordship.
was not sent up for trial. Molay.
And Molay Talukdar.
But these two professors were sent up for trial.
Exactly, Lordship.
But the charge sheet does not narrate what are the findings against them.
Page 77, man. Page 70, man.
That is most important, right?
And bail rejection order, man.
Huh?
Earlier, the trial court has allowed interim protection. After perusing the city matter, their bail petition are rejected.
No, I'm saying that in the charge sheet,
Fine.
what is the finding against these persons? This is the
No,
earlier
no
format
finding
of,
important.
this is
Page
slightly
77, madam.
77. Why has the IO sent them up for trial? You must have found something.
Nothing, Lordship, not an iota of any reporting of why they have been sent, Lordship.
Okay. That is what I want to find out actually.
Page 77 and 78.
77.
77.
Regarding my learned senior friends,
No, that only
That's
says
a-
materials in the case diary.
My lord,
subsequently High Court have granted bail. to
High
them.
Court granted bill on the condition that, my lord,
Even the Lordship may peruse page 80, Lordship, the High Court had reported that.
Page 80.
Yes, Lordship. At the time of granting bail, this honorable court had reported that on the
only on the consideration custodial interrogation is not required. Only on that condition, the bail was granted by the court. Here in the motion, when it
But
was
that
came
very
up for motion, my lord, it was not considered, my lord. Their prayer not considered, my lord. And thereafter notice
that very
issued, my
aspect
lord.
supports the contention, Lordship, of the petitioners. In the language of the charge sheet, in the language of the IO in the charge sheet is peculiar, Lordship, page number 83, Lordship.
But there is an observation, I mean, of this court, that the
Right.
case diary produced today does not reflect any incriminating material against the
Exactly,
present.
Lordship.
This observation is there. Anyway, we'll decide this. But
Can raise the question.
I think you are Mr.
And that's already.
MJ Chaudhary. I think we'll need the case diary because this is not insufficient.
Sure.
Ideally, in a charge sheet, each narration should be
Exactly,
separate,
Lordship.
given separately. Nowadays, it's given, but not always. But the special investigative agencies, they always
Yes,
do it
yes,
because why a particular person has been
Why it
charge
was
sheeted.
suddenly brought
It
up
may
in-
vary.
Yeah,
So
like,
the
everything
person
should
has
have
a
been-
right to know why he's being charge sheeted.
Right.
These are the findings of investigation. So you are being charged sheeted, ideally. But that I do not found,
Yes,
did not find here. This is a
Lordship may peruse page
all,
83.
old school charge sheet. But page?
Page 83, Lordship, kindly, Lordship, allow me to read it, Lordship.
I've gone through
The
this.
last
Today is
column-
only for orders, my lord, whether service complete or not, my lord. Only for that purpose it was coming, my lord.
So he's seeking a stay, that is why I'm.
My lord.
Okay.
Pertinent to state that although during my initial investigation stage, the accused mentioned in column 3 had been arrested, but since in the later stage, no allegation could be established. Why no allegation could be established? No mention by the IO, Lordship.
Release them.
Yes, Lordship.
Then
And but ironically, learned trial court also at the time of cognizance did not verify this aspect,
so
Lordship.
it's not clear, Mr. Sharma, it's not clear. We'll have to
Lordship,
get the CD.
TCR.
Okay, we'll
Till the state, Lordship.
okay, till the next, okay, that's okay. There's a finding also at this
Petition
court.
will be recorded.
Okay, no problem.
No trial for that, this year, search.
Only till third, Mr. MZ,
NZ, sorry, Lordship.
MZ Chaudhary. MZ, no?
NZ.
NJ Chaudhary, learned counsel for the petitioner, full stop. Who has drawn the attention of this court to last order dated 13/5/2026. Directing the petitioner side to submit a tracking report with regard to service upon respond number 2. Full stop. It is submitted in this context that due to some technical hitch in the website of the postal department, they could not download the report and seek some time for the same. And submit that they may be they may be given some time for the same, and also they are willing to take fresh steps. Full stop. The prayers are allowed. Full stop. The petitioner may also take fresh steps upon respondent number 2 by speed post.
My lord.
Full stop. By speed post. Full stop. The learned counsel for the petitioner submits that the petitioners are seeking quashing of the criminal proceedings arising out of what is this? Horlemuk PS case number?
645
Uh,
of 18.
Horlemuk PS case number 645 of 2018 within bracket PRC number 1627 of 2018. Full stop. It is submitted that the case upon completion of investigation resulted in a charge sheet against the 2 petitioners who are assistant professors.
Yes, Lord.
In which college?
Pragjudice College.
Pragjudice College, Gauhati. And it is submitted that they have been charge sheeted without justification. Full stop. The learned counsel prays for stay of the proceedings till the returnable date at least. Full stop. In this context, my attention is drawn to order dated 24/9/2018, passed by this court in AB 2767 of 2018, preferred by the two petitioners herein. In the said bail application, bail order, it was observed by this court that, yeah, page 80 underlined, you just, the case diary produced today does not reflect any incriminating materials against the present petitioners, both of whom are assistant professors of the aforesaid college. On this page 80, leave this, okay? Full stop. I have also perused the chart sheet. It is not clear from the chart sheet regarding the materials on the basis of which the petitioners have been charged sheeted. The case is stated to be at the stage of appearance. Call for the scan TCR. Align here. The learned additional PP objects to the prayer for stay at this stage. Call for the scan TCR comprising case diary. We'll need the case diary mainly. Case diary, charge sheet and other relevant documents from the learned court below. Full stop. Upon considering the matter, it is directed that further proceedings in PRC number so and so pending before learned additional CGM Kamrup M Gauhati shall remain stayed till the next date of listing. That's okay. Let it be.
Much obliged.
List the matter on. Take the date. 23/7.
Much. 43. Lordship. By the input order, my lord, my lord, the examination of my lord PWs as well as my lord evidences used by the my lord PWs held that trial court that will be not appreciated, my lord. Close the cross examination and held that the evidences will not be appreciated in the my lord case, my lord.
Expunged means
My lord.
without
Order
cause.
18, my lord, and listen.
It's a LA proceeding. LA.
In a LA reference case, my lord.
Bilasi par.
Case 18, kindly listen.
Just a minute. Some order sheets were directed to be produced.
Yes, that is, I
You brought. Page 18.
I have
Oh.
taken.
No, you.
If
Your-
you order page 18, my lord.
Page 18. Cross examination. Okay.
Thereafter petitioner filed my lord review application that was also rejected, my lord, as well as petition under section 151. Subsequently, that is also rejected. My only period is that my lord next date is my lord 4/7/26, my lord. Petitioner will available along with his PWs on that date, my lord. The government can net their cross examination, my lord. Only one opportunity may be granted, my lord.
How many PW witnesses?
Four PWs.
All closed.
All closed.
That's all.
All closed.
And how many witnesses were adduced from your side? Total?
Only four.
Four. That means all your witnesses were
Yes,
closed.
Yes, ma'am.
Okay.
So on the next date, we will available all the witnesses.
But there's some considerable anyway. You for the.
It's the impugn order, page number 19.
You are appearing for
And
which
appearing sole as government of Assam.
common
Lord. The heat order 17.
land was acquired for some. Which is the benefiting organization for
Yes.
the. It was acquired for whom? For whom?
Railway, my lord.
For the railways.
No, Lord, I am instead of Assam.
Yeah. The government acquired the land
Government
for its own use.
Government.
For its own use.
Then acquired by the government, ma'am.
No, sometimes it is acquired for some organization. Government organization. Anyway,
Several times they have
that is the main reason.
taken
actually.
the adjournment also. My only pyramid, one chance may be given, my lord. Otherwise, my lord, the entire case will go, my lord. And actually, the proceeding was, my lord, ex parte against the, my lord, government, my lord, all along, my lord. Kindly see, my lord. They are not appearing in the case. No, no. Up to, my lord. One 422. Case was proceeded ex parte.
Okay. Anything else? Anything else from your side? Nothing? Pay some cost. Not
Yes,
much.
sir, my lord.
Pay some cost to the legal service authority.
My
Don't worry, I'll not impose exorbitant. But still, because court's time is always valuable. At the same time, Tatari, all his witnesses have been closed, so it'll be
Answer.
4 witnesses. Mr.
Yes, sir.
H.R. Ahmed, and you, Mr. Burma,
I am T.R. Gogoi Lodge,
T.R. Gogoi, learned government advocate.
government advocate.
Learned government advocate. Full stop. The revision petitioner has filed the instant application against under Article 227 of the Constitution of India, read with Section 151 of the CPC 1908, agreed by order dated 19/1/2026, passed by the learned Additional District Judge Bilasipara, in LA case number 154 of 2017. Full stop. By the impugn order, the learned court below was pleased to close the to reject the prayer of the petitioner for adjournment for the purpose of cross-examination of his witnesses, and after dispensing with the cross-examination, held that the evidence in affidavit, adduced, the examination in chief adduced shall not be considered for adjudication. It is submitted that subsequently a review petition was also filed.
What are space 27?
Seeking review of the said order, but the same was rejected. White order dated 27/4.
6/4/26.
6/4/2026.
As well as petition under section 151. That is rejected by.
An application under section 151 of the CPC was also filed, and that too came to be rejected by the order dated 27/4/2026. The revision petitioner is prosecuting the LA case seeking enhancement of compensation vis-a-vis the award of the collector. Full stop. It is submitted that he has adduced in evidence the testimony of 4 witnesses. 4 witnesses, and by the impugn order, all the cross-examination of all the 4 witnesses was dispensed with the further further observation that the examination in chief of these witnesses will also not be considered. Full stop. I peruse the impugn order. The learned additional district judge has stated about several adjournments being taken, and the order came to be passed in the backdrop of such repeated adjournments. White order dated 22/5/2026, passed by this court, the petitioner side was directed to submit copies of the order sheets to throw light on the adjournments sought for in this regard. Accordingly, certified copies of order sheets have been placed. When was I'm giving you the relief, but just asking what is the, when was the evidence filed?
Last evidence from my lord, PW 4/11/24, my lord.
It is submitted that testimony of examination in chief by way of affidavit
Affidavit, my lord.
was of PW 4 within bracket. The last witness was filed on
4/11/24.
4/11/24. Needless to say that it is clear from the materials that there was considerable delay in making the witnesses available for cross-examination, and in the intervening period, several adjournments had also been taken. We'll stop. In that situation, the learned reference court had its own justification in disallowing further time for cross-examination. This aspect is also pointed out by the learned government advocate representing the state, which had initiated the acquisition proceedings. Next paragraph. I have perused the relevant materials and considered the submissions. The petition, undoubtedly there has been delay in the proceedings due to the multiple adjournments taken by the petitioner side. However, it cannot also be overlooked that the proceedings pertain to property rights, and the cross-examination of all the 4 witnesses adduced by the petitioner side have been washed away by the impugn order, and therefore the dismissal of the reference proceedings in the present form seeking enhancement would be a foregone conclusion. Full stop. In such view of the matter, the learned counsel for the petitioner submits in this context that one opportunity may be given to him, and he shall produce all his witnesses for cross-examination and proper adjudication of the matter first. In the given facts and circumstances, the impugn orders dated so and so are set aside in the larger interest of justice. You want a fixed date?
Date are already there. 4/7/26 is the next.
The next date is stated to be fixed on 4/7/26. The petitioner shall make available his witnesses on that date for cross-examination, so that the proceedings can move ahead. Full stop. The reference petitioner shall deposit a cost of rupees 2,000 before the District Legal Service Authority. Bilasipara will be Dhubri.
Yes.
Dhubri, right?
Yes.
Before the learned court, which shall be transmitted to the DLSA Dhubri.
Lord. Deeply obliged.
You can take this back.
Hello.
Your certified copies. You can take it back. Did you go?
45.
As per office note 19.6, services are not served, but my learned friend is appearing for response number 1 and 3.
Okay.
2, we have to take fresh steps also.
1 and 3.
1 and 3 is appearing today.
I have filed color number, date. My lord, I have not received a copy, but I have come to know about pendency of this too.
Fine.
When the certified copy of the
Order of the Alam Court before execution.
I'll serve the copy tomorrow. And
We'll
I
serve
will-
you a copy.
Yes.
I'll take this fresh step upon the response number 2.
Heard Mr. Bhanto, learned counsel for the petitioner submits that fresh steps shall be taken upon respond number 2. It is submitted by learned counsel for respond number 1 and 3 that upon getting information about the litigation before the learned executing court, he has been instructed to enter appearance on behalf of respond number 1 and 3, and he has also filed wakalat nama, but further submits that he may be furnished with the copies. The petitioner shall furnish extra copies to the learned counsel. You'll take steps by speed post?
Speed post.
The petitioner shall take fresh steps upon R2 by speed post.
Interim order may be concluded.
It was conditional stay or part stay?
Yes, condition.
Conditional stay.
Yes.
There is a no bar for execution.
Pardon?
There is a no bar for execution.
It is made clear that if the decretal land should not be a part.
Paragraph.
Full stop. The third last paragraph.
Yes.
Stop. It is submitted that the petitioner was granted an interim order by the order dated 1/6/2026. Para 11 of the said order is extracted here in bill. Full stop. The same said interim order stands extended till the next date of list. When do you want a date?
Also after vacation,
Yeah, after vacation.
because we have to take steps.
Yeah, after vacation. List after 4 weeks on a date to be fixed by registry.
Public.
Some dates we should leave also. Contempt.
Office not reveals.
This matter, no, I know this.
And answer not.
I know this matter will run into problems, but anyway, I'm not surprised that this is run into problems.
Awaiting since 2010, madam, the petitioner is suffering.
You have taken the steps?
It may be avoid service, already steps has been taken by.
I see. Here is the Miss Baharul Islam Learned Counsel for the petitioner who submits that steps have been taken by speed post. As per office note dated 25/5/2026, the service report is not received back. We'll await.
Alright.
You want to take by Dusty also?
Oh,
Await service report. Further, the petitioner is given the liberty to resort parallelly to Dusty service upon the respondents. And in the event of resorting to Dusty service, the compliance affidavit shall be filed for the scope. List on, we'll give a date. List on 21/7, Tuesday.
Publish. Publish.
May I please your lordship, proceed is a delay condonation petition, 33 days level.
Okay.
Other side appeared in.
RSA.
I say, your lordship.
The civil judge Hailakan list. Can you help me with the relevant para? Explaining the delay.
5 and 6 particularly, page number 4.
Okay. What did you say?
But, my lord, I mean, there is nothing unreasonable in it, so I leave it.
No objection.
Yes.
Stop. Mr. Mojumdar,
R.S. Chudhary.
R.A. Mojumdar, learned counsel for the petitioner, and Mr.
And name Ajay.
N.A. Machal, yes. Learned counsel for the respondent. Full stop. The petitioner, the applicant herein is seeking to file a regular second appeal within bracket RSA against the judgment and decree dated 1/8/2025, passed in TA title appeal number 8 of 2024 by the learned civil judge, senior division Hailakandi, full stop. However, there is a delay of 33, there is stated to be a delay of 33 days in preferring the said RSA, for which an application under section 5 of the Limitation Act 1963 has been preferred for condonation of the same. The learned counsel has drawn attention of the court to the explanation of the delay, which is narrated in para 5 and 6. It is, in a nutshell, it is stated that after the after he obtained certified copies and returning to Hailakandi, he was stranded due to some geographical conditions. Subsequently, he also fell ill and unable to take steps. It is also stated that it's also stated within bracket para 6 that financial hardships also contributed to some more delay. And eventually the appeal was filed on 18/12/2025 with a delay of 33 days. Mr. Major Bhuya fairly submits that he does not have any objection. Full stop. Considering the quantum of delay and also the explanation put forward, full stop. This court is court of the view that the delay should be condoned in the interest of justice, so that the second appeal can be heard on merits. In such view of the matter, the delay of 33 days in preferring the RSA is hereby condoned. The IA stands allowed and disposed of. The RSA may be put up for
On 27, your lordship, because there is execution case pending.
on 27,
27 this week, your lordship. 26, your lordship.
last day.
Immediately after vacations, my lordship, this is my limited plan, because I mean.
It can be on, this is civil matter, so it can be on 13th, on the day of reopening also. Can
The problem is that
14th of July.
execution case is pending against me, your lordship, and 6-month limitation is there in lordship, so far as execution case is concerned. I have
Already
some
constraint
time-
subject for my learned friend.
Hmm?
I have some issues regarding, I mean,
They're on the
board with vacations, my lord.
Immediately after reopening, 13th, or you want 14th?
I want for.
13th, I'm giving you first day after reopening. Civil matters, so don't have to. 13/7, okay?
May I please your lordship. Lordship, kindly take up IS Civil 1523 of 2026, lordship.
Okay.
This is filed by the appellant lordship. This is the regular second appeal. I am the appellant lordship. Appellant and the main respondent number 1 to 4 already settled the matter between themselves. When lordship, they have executed one sale deed of settlement also, lordship. I have annexed that also, lordship, annexed page 10, lordship. So I want to withdraw this second appeal.
This
lordship.
IA is filed for withdrawal.
We withdraw.
Okay. Very much. Very good. Civil matters can be settled also. Heard. And stir. You are appearing for the pro forma respondent. You are for, sir?
Or respondent.
All respond.
Respondent.
1 to 4. 1 to 4. Victim names, full stop. Ms. Bhattacharjee, learned counsel submits that in the meantime, the parties in the connected RSA within bracket RSA 185 of 2019 have arrived at a settlement void deed of settlement dated 2/04/2026. Full stop. A copy of which has been annexed with this IA. It is further submitted that in the context of the said settlement arrived at between the parties, this IA has been filed seeking to withdraw the RSA. Full stop. The learned counsel for the respondents concurs with the said submission of the appellant side. In view of the aforesaid positive developments between the parties, the prayer is allowed, and the RSA being RSA 185 or 2019 is allowed to be withdrawn. The IA stands allowed and disposed of.
RSA also disposed of.
Disposed of. Anything else?
In RSA lordship, that is also disposed of.
Yeah, that will be disposed and order will be necessary. In the context of order passed dated so and so in the IA, allowing the prayer of the applicant to withdraw the RSA. The instant RSA stands disposed of on withdrawal.
Okay.
The delay of 8 days.
8 days in preferring the review application.
Yes, yes.
You're contesting the delay. Yeah, civil matters. Okay, let them file then. 2 weeks will be after the application. Full stop. The present IA, नाम तो लिख दूंगा 1603 is for condonation of delay of 8 days in preferring a review application. Full stop. The learned counsel for the respondent / opposite party submits that the respondent would like to file an objection and seeks 2 weeks time for the same. This is the matter on reopening. I'll fix it. On reopening. When? On 13th? 13th or 14th? Okay. After 2 days. Okay, let it be on 16. 16/7. In the meantime, the respondent the liberty to file objection if any.
Deeply obliged.
Aru beleg like bani order. Eta nalag.
51.
Yes. Mr. Paul.
It's also an application for granting for condonation of delay of 52 days. In filing the connected civil division petition.
CRP. You're filing a civil revision. Title appearance. Who's for the other side?
Notice to be issued.
Huh?
Notice to be issued.
Oh, it's a new company. So anyway, heard Mr. A. Paul. This IA has arisen out of an application under Section 5 of the Limitation Act 1963, seeking condonation of delay of 52 days in filing a civil revision petition against judgment and order dated 11/9/2025, passed in TA 11 of 2019 by the learned Civil Judge Senior Division, Kamrup Amingam. Steps of notice shall be taken upon the respondent by speed post. To nowadays, no step by speed post. List after 4 weeks. After 4 weeks.
A date may kindly be.
20th July 2020. 20th July 2020.
Wait, please, your lordship. Lordship, the respondent side has filed an affidavit in opposition. May the matter be kindly listed for admission hearing, lordship.
Just a minute. Madam, you're appearing for the,
For the response.
all the respondents.
Everything is right, office dated 26, already tagged.
Okay. You're agree by filing of additional issues, additional issues. So what is your submission? We'll fix it for admission as he says, huh? After vacation.
Lordship, interim order passed earlier may be continued.
Okay, that is there. We'll stop. You're Mr.
JP Boysha.
JP
JP Boysha.
Boyso and Madam
P. Sarkar.
B. Sarkar, counsel for all the respondents. We'll stop. It is submitted by the learned counsel for the petitioner that the matter may be posted for admission hearing after the vacation. Ms. Sarkar, Mrs. Sarkar, learned counsel for the respondents submits that you filed affidavit.
Tagged.
Has filed an affidavit in opposition, which is tagged with the case report. First. By an order dated 4/6/2026, further proceedings of TA 2 of 23 pending before learned additional DJ Kasar Sil was stayed till next date of listing. The interim order shall continue till the next date of listing. List the matter. You want a date, specific date?
Lordship, after vacation may be listed.
No, let it be. We can fix a date also. 28 July, Tuesday, 28 July, 28, 28.
Much obliged.
In this case, we are representing respondent. As per order dated 20th of April, the petitioner and legal advocate withdrawn their wakalat number. So none to represent on behalf of the
Just a minute.
petitioner.
Okay.
Can it be referred before the law Zima for clearance this technicalities?
Yeah, that's a good idea, maybe. Just a minute, I'm having a look. In this situation, usually a notice is issued to the
That is direction.
litigant.
Direction is there, Lordship.
Yes, yes, okay. Right. You are Mr.
K. Roman.
K.
K. Roman. Lordship.
K. Roman, learned counsel for the respondents. None appears on behalf of the petitioner side. It is pointed out by the learned counsel for the respondents that the petition counsel for the petitioners withdrew the wakalatnama, which is reflected in the previous order dated 28 April 2026. Full stop. It appears that it's not clear as to whether the party, the petitioner, has engaged in a new counsel. In this context, the learned counsel for the respondent submits that the matter may be referred to the Lavazima court for doing the needful.
Right.
I find force in the said prayer. Full stop. The case may be listed before the Lavazima court. Any date, specific date?
Right.
I don't know which days they sit nowadays.
They still will say.
Decide. List before the Lavazima court after the vacation.
Right. Obliged.
Criminal appeal. You are appealing, sir?
Lordship. Lordship, it is a case of against equity, Lordship, under
Okay.
section 138 of Negotiable Instrument Act.
Okay. Original PCR is available. What
Lordship,
about, they have appeared? They have,
none of the respondents.
you're for the appellant.
Yes, sir.
Our core had appeared on the last date for the respondent. Wrongly written. हमारे बोले थे order लिखा था. I sailed the order. Just a minute. They have not appeared as per Lawazima court order. Notice is served,
Start, Lordship.
but they have not appeared.
Yeah. But the last two occasions,
But,
counsel from the legal aid has appeared exceptionally.
Acha. Because since it's a,
Legal
you're
aid.
questioning, you want to reopen the question, acquittal, so they
Yeah.
should appear,
Yeah.
right? But what can we do at this stage? Would you like to take fresh steps? It will consume some time. But Motiu Rahman, yes, there is no second respondent.
Yeah.
He's the only
Yeah,
person.
yeah.
Full stop. I would like none appears on this thing. Peruse the order dated 28th February 2026, passed by the Lawazima court. Holding that service upon the respondent has been responded. Motiu Rahman
Whatever.
is completed. Full stop. What do you suggest?
But so it is a,
Dusty, would you like to try Dusty once? Dusty service. Criminal matters usually we don't, but this is a complaint case.
yeah, complaint.
And he has been acquitted also. You can try Dusty service once, and in the meantime, we can fix it for hearing.
Okay, Lordship.
That we can do. And submit the compliance affidavit. Full stop. Considering the fact that the present appeal is by way of challenging the acquittal of the respondent in CR case number 1946 superscript C of 2013, the appellant shall take a fresh round of steps upon the respondent by Dusty, and thereafter file the compliance affidavit. In the meantime, the appeal is admitted for hearing. Full stop. The original TCR is already available. Full stop. List the matter in the orders column for after the vacation on 30th July.
38 July, Lordship.
30th July. You just do the Dusty service, file a compliance affidavit. Otherwise, then it will be ready for
Yeah.
hearing. Let's see what happens. 30th July.
Lordship.
Yeah, please, Your Lordship. Lordship, in this case, I raised some time to file my objection. The local council in Golpara, he was not well, so he was not able to provide some documents which we sought for.
Okay.
I just pray 2 weeks' time, a date will be fixed as per the convenience of my.
Mr. Singh?
Yes, my learned friend is all right, he will seek for time. But I am sorry to say that 18 to 2026, time was taken.
Okay,
Hereafter, my lord, 3 months, 4 months have left.
that is true.
Now again, my friend asking for some time. My lord, my only prayer will be, this will be last chance.
This time he'll have no excuse because there is a vacation, 2 weeks, unless he's going for a long holiday, which he may,
That is
we
the
never know.
option he will get, no problem, but this should be a last chance, my lord.
He's anyways protected.
My lord.
There is an entry
Well,
model.
Please file, no?
Protection is.
Please file. If you want to file
I'll file.
you have the time also, seriously, also, 2 weeks holidays are there.
After vacation, a date may be fixed and last chance may be given, my lord. Otherwise, this instruction, etc. will not.
So, heard Mr. M.A. Sek, Learned Counsel, and Faridi, Learned Counsel for the respondent. Mr. Faridi submits that they have to get some documents from the council in Gwalpara for filing an objection, and those documents have not been forwarded due to the council being unwell. And
Medical
seek
emergency.
some time, 2 weeks' time for the same, full stop. Mr. Sek, Learned Counsel submits that the respondent is at liberty to file an objection, but already several significant period has elapsed for the same, drawing attention in this regard to order dated 18 to 2026. The respondent side shall endeavor to positively file the objection, if any, by the next date. Full stop. Leave the matter after the vacation on. You please tell me a convenient date from your side.
Any date after vacation.
28.
28, is it okay for you? 28,
Yes, ma'am.
28/7.
Bad please, your lordship. Kindly pass over the matter for the day as my senior is engaged in another.
This is a case for visiting rights only.
Just a minute, okay, if you do not
What?
want.
I am the grandfather of the children who were taken away. Now it's a mother at Tinsukia,
Learned Counsel for
who has granted simply once in a visiting right and talk to WhatsApp. They have challenged that part.
some service is awaited. You are for? You are for
And for the respondent number 1,
one.
3 and 4, they have withdrawn lordship. They are not going to face for 3 and 4.
They have withdrawn. They have withdrawn.
There is an order lordship. If you are planted or.
Okay. Will
They are not interested. Because 3 is her husband.
you are for 1 and 2.
Yeah, lord.
Okay, heard. Okay, we'll fix it another date. Your good name, please.
Tidas.
He does Learned Counsel for the petitioner.
He is
SK
the
Porter.
father of the complainant.
Learned Counsel for respondent number 1 and 2. Can you help me with the order where I'll reflect it so that for further reference, future reference? They have withdrawn, no? You said?
Lordship interim order earlier passed.
That's okay. No, 3 and 4 have.
Yes,
Oh, mhm.
their order was there.
Good stop. By the order dated 27, as pointed out by Mr. Poddar, Learned Counsel for R1 and R2. By the order dated 27/4/2026, the respondent number 3 and 4 were struck off on the prayer of the Learned Counsel for the petitioner. And that these 2 respondents were performer respondents. Ms. Das, Learned Counsel for the petitioner, fix another date as a leading counsel is stated to be preoccupied in another court. When should he fix on?
17th of July, lord.
After vacation? After vacation? List on 17 is okay for you. Okay, 17.7. The interim order by order dated 5/12/2025 stands extended till the next date of list. Okay.
All right.
Number 12. Lordship, my finally will be order dated 25 March 26, Lordship. There was an observation by this honorable.
25 March 26.
Yes, Lordship.
27 March.
There has been no objection filed in it, Lordship, and we have had to suffer prejudice, Lordship. The petitioner is a lady having medical issues, Lordship.
Okay, you filed the objection.
No, Lordship, not yet.
On the last occasion, Lordship, the matter could not be taken up due to paucity of time. Thereafter, a date was fixed.
Mm.
That admits
We were ready to argue on that day as well, your Lordship. Even on subsequent date, we are ready to argue. We will not prejudice the petitioner based on not having filed the objection.
because we have some
But your Lordship, when a date has been fixed, then if the petitioner then goes on and mentions the matter and fixes without us knowing, then on that particular day, Lordship, we cannot be expected to argue the matter.
Lordship, they way before.
It was fixed today. You didn't know.
No, Lordship, it was fixed on 23rd of July because we did not fix it. We did not want it to fix today because we already had a lot of hearing matters, Lordship. But we were not consulted when the mention memo was filed. Neither any particular reason was given.
Lordship, as for my limited knowledge, for mentioning a matter, I don't think there is need to consult that. For listing of a matter, there is no need to consult the respondent beforehand, Lordship. And the petitioners, they in the trial court is.
Maybe anyway, let's move forward.
Yes, Lordship.
So it has come up today for
Admission, Lordship.
Admission, Lordship.
Lordship, the matter basically, Lordship, apparently there is the FIR, original FIR, Lordship.
quashing.
Yes, Lordship.
You're seeking quashing.
Page number 101, Lordship.
Lordship, since the date was already fixed on 23rd July, we were not particularly prepared for this. Since they had mentioned and brought it up, that's their urgency. But we were not particularly prepared for the case today. So Lordship.
Even if the stench is admitted, Lordship, they have taken time for filing objection long back, Lordship. So.
But if the last day the matter had been taken up, we would have argued the matter, Lordship. But that does not mean that the judicial order would be overpassed by mentioning it, Lordship.
It was fixed on okay.
That was by the order.
Oh, just a minute. Also heard. Office notice for trial courts have been received in the meantime.
Yes, sir.
And the CR has been received. Let this case be listed again. Oh, acha. It's already fixed on 23rd.
That I admit, Lordship.
It will be better, I think, to keep it for that 23rd only, isn't it?
Lordship may fix it, but interim.
But
proceeding may be stayed, Lordship.
What do you want to say? You make your submissions quickly, since you have.
No, Lordship, let them make it that day because the arguing counsel is not available today. Mr. Reddas is already occupied in other matters. Lordship. He may not be able to make it today.
Suffering from repeated
You are seeking quashing of the entire proceedings,
proceeding, Lordship.
which is at the stage of appearance.
This has almost reached evidence.
Next date on evidence for
It's 1st of July,
For
Lord.
1st of July, Lord.
So there is
So
inconvenience caused,
no
Lordship.
additional prejudice will be caused if.
Because I do not know the facts, so I cannot say anything.
Exactly, Lordship.
I have to enter into the facts, right?
Lordship
Whether-
will record that if we do not file objection, Lordship will hear us on the matter and decide on the
That was
next
already
date.
recorded on 27th of
Yes.
March, Lordship. They have entered appearance.
You mentioned the matter for the purpose of praying for the interim stay.
Interim, Lordship, I'm ready to.
Full, no, they will not be ready to, because next day, let us fix it on 23rd. You can argue the matter.
Yes, Lord.
And in the meantime, you file an objection
But otherwise,
and give a
Lordship,
copy to him. And on that day, we can try. This is a 25 matter.
Yes,
Still, they are older matters, but we can
Lordship, what I
try for disposal also. at
One
the-
of the very alleged incriminating material on the basis of which the informant has lodged the FIR.
Mm,
That thing has been already set aside by this honorable court.
acha. Okay.
Okay, I can, there is a judgment, Lordship, I finally peruse page number 70, Lordship.
Let me see what is stuff. Can you take me to the charge sheet? I'll just spend
There's no
5 minutes on
transcript.
this.
What had happened is that after initial lodging of the FIR, there was final report.
Okay,
Then he lodged
complaint.
Objection.
Okay,
Subsequent to his acceptance of his objection by the learned trial court, the trial is proceeding now also,
as a complaint case,
as a complaint case.
as a complaint case.
Objection is at page number 111, Lordship. Matter basically relates to service related issue, which
And can I see the, have you annexed the final report?
yes, Lordship, that is the final report. Order is at Lordship, page number 110. We have not access to report, Lordship, but there's a mention in the trial court order itself, Lordship.
No, final report, you have the
That
final,
we don't have access.
you don't have? final report is given.
Yes, that was given in the trial court, Lordship. That observation.
You get,
page number
you-
110, Lordship.
You should, I think you should procure the final report also, because this will be necessary for adjudication of this. What did the IO say? This is a very important thing in your favor. What did the IO say to arrive at the finding that there is no case against you?
Yes.
So that document you should have, actually, you should also file an additional affidavit bringing that thing into record. So you can do these things in between. And we'll,
It's a hefty petition, Lordship, 33 annexures, lot of things to go through, even the depositions of witnesses are there. Final report has to be analyzed. So it will take time, Your Lordship.
Full stop.
That is why.
Mr.
Document page number 68 for once, Lordship.
68.
68, Lordship.
It would have helped us, all of us to peruse the final report today, because that would have, helped to decide the question of stay. But anyway, we'll keep it for next day. Page
68, Lordship.
68.
This is one inquiry report conducted by the District Elementary Education Officer, Lordship. This is one of the very document which the informant has relied in his objection and the FIR.
Submitting fake school certificate.
Yes,
So anyway,
but this document has already been set aside by this honorable court. Lordship, may peruse page number 79, Lordship.
in read petition.
Yes, Lordship. Series of writ petition was filed against the conducting of inquiry. Lordship, in page number 17, paragraph 21, Lordship, I am taking you to last line of the page number, paragraph 21, Lordship.
So there was procedural infirmity in the
Yes, Lordship.
inquiry proceedings. It was set aside.
Which does not render the allegations false, Lordship. The
There are
information derived.
other
is
material
questionable.
check
Maybe
is
anyway,
very satisfy.
I think let us wait for this thing. You'll not be prejudiced. She's on bail, right? Complaint case.
Yes,
There
Lordship.
shouldn't be a problem.
Ishmael, Lordship, she is a retired lady, Lordship, having medical issues. Repeatedly, she agreed.
Learned counsel for the petitioner and Mr. A. Mishra, learned counsel for the. Your respond number? Two, full stop. Learned, your Bhattakur, I will record your name. E. Bhattakur for addition. Full stop. By order dated 26/5/2026, the matter has already been posted for on 23/7/2026. The scanned TCR has been received in the meantime. Full stop. It is submitted by the learned counsel for the petitioner that the FIR filed against the revision petitioner resulted in a final report by police, whereupon the respondent number 2/informant filed a complaint, and now the matter is proceeding as CR case number 698 of 2022 before the learned JMF State Dhubri. Full stop. The petitioner is seeking quashing of the said criminal proceeding. Complaint case proceeding. Full stop. The petitioner also has a prayer for stay. Full stop. The respondent number 2 has not yet filed an objection. Full stop. The respondent not yet file an objection. It is at liberty to do so by the next date. Full stop. And list the matter on 23/7/2026 in the admission column.
Yes. Much of lordship.
To public forum, treat, huh? No, 3:30. 3:30.
13.
No, আৰু বহুত আছে ক'ত এইবিলাক আছে ন টাইম লাগে ন টাইম হৈ পেলাই হ'ব একেলগে শেষ কৰি দিম আৰু ন Yes, please.
Lordship, is for quashing of FIR, Lordship.
FIR.
Yes, yes. There is page 14, Lordship.
Okay, page 14 is the FIR. We'll need the case diary, of course.
It's a vocabulary part, Lordship. Is it?
Lordship, I am the respondent number 2 in this case, Lordship. Actually, matter pertains to Lordship, the processing of a land from the petitioner by the respondent number 2 in this case. And here should be controversy between the transaction made between the petitioner and the respondent number 2. In this case, Lordship, the respondent number 2 seeking certain bank statements for the bank, but that has not been provided. And she is originally resident of Calcutta, and she is also not available, for which I could not file the affidavit in opposition, Lordship.
He was the purchaser or seller?
Purchaser, Lordship.
Purchaser.
I need some time to bring those particular records to file the affidavit in opposition, Lordship.
The fact is that it's a pure civil in nature. There is no criminal intervention in this case, Your Honor. The prima facie case is.
You study, all of you are quite knowledgeable in these things. So FIR, if it does not make out anything, then it will be liable to be quashed. And that's why it is at the stage of investigation, it is always difficult to say whether, it makes out, and because so therefore you have to go by the FIR on its face. FIR on its face. Anyway, so CD will be necessary in any case, and you bring on record those documents after the petition. Yeah. Anything else from your side?
Only big, that
Okay.
it's a civil in nature.
Yeah, I'll record that summation.
Yes. The last two occasions.
Pure civil dispute, that is the law as we know. No? We have studied and that's the law. If it is a pure civil dispute without any criminal dimension, it should be quashed.
Yes.
If it has a criminal dimension, then that's different. That will proceed on its own path.
It is a intention to harass me. Only one thing, Lordship, last two occasions, police has failed to provide the case diary, Lordship.
So
Petitioner continuously threatened the respondent number 2, Lordship.
No, Lordship is.
Roha,
Yes, it's-
Mr. Your good name, please.
T. Burman, Lordship.
Lee Burman for respondent number 2, P. Bhattakur for Mr. Thakur. For Mr. For the petitioner. The counsel for the petitioner submits that the dispute between the parties is of pure civil nature, and the criminal proceeding constitutes an abuse of the process of law, and therefore the petitioner is seeking quashing of the same. Mr. Burman, learned counsel for the respondent number 2, submits that the said party resides in Kolkata and he has to procure some documents to file an affidavit, and therefore some time may be given to him. The learned additional PP submits that the case diary has not been received. Issue reminder for the case diary. In the meantime, the affidavit, if any, shall be filed by the respondent number 2. List the matter on. You can
So 20, Lordship.
Is it okay for you?
20th of July.
20th of July. 20. Criminalization is there, civil dispute, that is the law, that's why law is come, that is law come, but this problem of, not all civil case, criminal, business, not all transactions, apparently civil transactions, are sought to be converted into criminal, some of them are.
Yes.
And that aspect, therefore, this law is emerged. But while tackling this issue, we should also think of another larger issue, which is we must speed up the civil justice system. And that is the root, actually.
Yes.
People, we have to speed up the remedies in the civil justice system, which is extremely important for people, civil justice system.
Deeply obliged.
1415.
Fourteen 15. I didn't have Loilam. This was the extension portion,
Yes.
and the bail,
In the,
connected bail.
it arises from the same order.
Uh.
In fact, in the criminal petition lordship, my objection is ready, but the parties were not properly arrayed. The order also does not reflect that the correction has been made. Lordship, my objection is there. I can file it tomorrow itself. Lordship, you kindly see the orders fast. And the orders that have been uploaded does not disclose.
We have
that-
filed it long ago, my lord. It is in the record, my lord.
Last order does not indicate that.
Regarding correction of the cost title.
Okay, amended cost title has been filed.
Yes.
Anyway, so Union of India Prosecuting Agency, NCB.
Then lordship, it may be taken up day after tomorrow, by tomorrow.
You'll file it. Bail is also connected, right?
Yes, yes.
Same order, lordship.
Extension is challenged from the same order. Extension is.
Only issue is that extension was given violating the norms and the guidelines of our Gauhati High Court and the Apex Court.
Extension was given.
Until today, charge sheet has not been filed,
Anyway,
even after extension.
SC Biswas Land Council and KD Chaudhary, learned Deputy as the Solicitor General of India, full stop. In terms of order dated 12/3/2026, the amended cost title has already been filed by the petitioner side, showing the Union of India as the prosecuting agency, full stop. The case is being prosecuted by the NCB, full stop. Narcotics Control Bureau, full stop, which is being represented by the learned Deputy SG, who also submits that the objection on behalf of the NCP is ready and praised for listing the matter on Thursday.
Yes, 25th.
List on Thursday, 25th, along with BA 3617 of 2025. তাতে লিখি দিব পাৰে অৰ্ডাৰটো দুটাই থাকিব তাতে ব্ৰেক ল ফৰ ইট okay on Thursday. Five minutes.
Has also corroborated the case of the plaintiff. As the defendant has failed to repay the loan amount, furthermore, when the suit was filed within the limitation period, the plaintiff is entitled to get a decree for recovery of the said amount of the defendant. Basically, this is the findings of the First Appellate Court. The First Appellate Court basically relied upon the Exhibit 4, which is a so-called agreement. Whether lordship that even though lordship is some petition plaintiff adduce any evidence exhibiting some documents, it is the bounden duty of the court to lordship verify the authenticity of the document. Whether it was lordship properly executed, this agreement was properly executed, that has to be looked into. So trial court has minutely lordship verified all those contentions that whether this agreement was accordingly proof as per law or not. Now the lordship, the basic allegation of the plaintiff in his plaint is that lordship, the text of the plaint, if lordship go by the plaint, at lordship will have the plaint that
Established, there were no verbal limits of the huge amount of lawful, the aforesaid reasons criminal
Plus.
not referred.
page 8, page 7.
Signature to finish. That means it was the learned trial court had disbelieved the transaction because there were no witnesses.
Yes. Actually, the fact is that, Lordship, the contention of plaintiff was that during the Lordship period of March 17 to June 17, he has borrowed lent rupees 17 lakhs to this present appellant without any Lordship exhibiting any documents. And it is also the case of the president on the against that said loan amount. This appellant issued 5 check, but the trial court has relied upon the check that were issued Lordship as 5 check. Not a single check was deposited. So trial court has basically also emphasized that since there was a case, 5 check were issued.
But none were deposited.
None were deposited. So once this, although Lordship concurrent proceeding may be initiated either in 138 or Lordship in money suit. So Lordship trial court has relied upon that since there were 5 check, why this plaintiff did not deposit a single check? Had there been any legal enforceability that he could have Lordship at least one deposited in his account, whether it is honored or Lordship it will be dishonored. That was different. So Lordship, on the basis of those contention, the trial court Lordship found that there is no case at all and there is no cause of action to file a suit. Accordingly, it was dismissed.
And the appellate court also went into this aspect that there were no witnesses.
Appellate court found that 2 attesting witnesses were examined as
Oh,
2 and 3.
Yes,
But
that's
their evidence are undisputed because since it was not cross-examined. So it was found
no,
undisputed and accordingly it was.
two attesting witnesses were also there.
Yes. 2 attesting witnesses, they adduced their evidence, Lordship, but they were not cross-examined. So Lordship, basically,
Substantial question, does it arise really?
basically, that is my also I mean stake Lordship to it is a substantial question of law. That is why Lordship I have filed another application under order Lordship 41 Rule 27, only to Lordship permitting me to adduce my evidence so that Lordship that proper adjudication can be taken place in this case, Lordship. That has been numbered as 1597. So Lordship, I am Lordship. Now I am in stake because I did not reduce, even I did not file it with WS. So it's very difficult to Lordship.
But it's CPC.
In my petition, Lordship, it was wrongly typed as order 14 Rule 28. It should have been Lordship 27.
CPC. Or paragraph note.
Loss.
Is on him.
27.
Additional evidence can it be taken by second appellate court?
Lordship, it's
We have to see
Lordship,
some case laws then.
uh,
Otherwise, we have to frame a substantial question of law. Otherwise,
Lordship, yes,
for the purpose of admitting, otherwise it
yes.
will not be admitted.
Lordship.
Because I do not per se, I do not see much of a substantial question of law
Yes,
here.
that's.
I do not see much
Yes,
of a substantial question of law actually,
Yes.
because the court has over that. This is a matter of appreciation of evidence.
Yeah, Lordship.
That just because the court has believed the evidence which was adduced, you know. So
In appeal state Lordship, it is normally permissible Lordship only on clause 2 of 27B Lordship may have order 41 Rule 27.
27B,
B.
production of additional evidence.
At the appellate court requires any documents to be produced or any witnesses to be examined to enable it to pronounce judgment or for any other
What you are reading, section, rule,
Rule 27, clause B.
clause B, the appellate
Clause
court requires, okay, let us read the parties to an appeal shall not be entitled to adduce, whether oral in the appellate court, but if, that's true, but as you know, the mandate of a second appellate court is very limited, right? It's
Lodge.
only a question of law.
But on
So
the-
you cannot even reappreciate evidence unless it is perverse.
Yes, Lodge.
So, so that I think unless there is a judgment, we see a
Lodge.
judgment which
Lodge.
says that in even second appeal you can direct, a recording of fresh evidence.
Lodge,
It
I
will
am
be
good.
difficult.
Yes,
I may not know, but you can show.
Lodge, I am good.
But this provision is broadly, by and large,
Limited
applicable
scope
to a
is
first appellate
Yes,
court.
yes, scope
Though
very
only
limited,
the
Lodge.
appellate expression appellate court has been mentioned
Lodge.
because the first appellate court is a court of facts also, right?
Yes. Lordship will have the first one at, it was reported 2026,
Yes,
Supreme S 27.
Okay, this is a
Govin
good
Singh
point.
and others.
Appeal against the order of high since second appointment. Certain I have been to notice of lay application, which is application. Oh, okay. Which paragraph should we go?
Lordship, may kindly first have the page 2028, 8 Supreme,
2008.
8 Supreme, 414. Paragraph number 4 and 5.
The name of the case.
His Lordship, Jitendra Singh and others. versus
this one.
Meher's.
This one.
Lordship, para 4, that's and
There are 4.
Sorry.
Let us read. That's fine.
While deciding second appeal, however, the High Court had failed to take notice of application under Order 41, Rule 27 of the Code of Civil Procedure and decide whether additional evidence could be permitted to be admitted into evidence. In our view, an application for acceptance of additional evidence under Order 41, Rule 27 of the Code of Civil Procedure was filed by the appellant. It was the duty of the High Court to deal with the same on merits. And that being the admitted position, we have no other alternative but to set aside the judgment of the High Court and to remit the appeal back to it for a decision afresh in the second appeal along with the application acceptance for additional evidence of so and so. So in this case also the situation was errors, Lordship. Accordingly, this application was filed. The High Court, Lordship, this High Court initially it was rejected, Lordship. I think that it was not necessary. So Honorable Apex Court has remitted back that issue, Lordship, to decide if the issue afresh. The next one is also, Lordship, Gauhati Singh, others first Union of Indian others. It was in paragraph number 11.3 onwards.
Govind Singh.
Lodge.
Para 11.
11.3. Which I am reading 11.3. Rule, just may I read, Lodge. Internal case 7.
Yes, got it. Rule 27.
11 point. Rule 27 being caused in a negative term, make it abundantly clear that the parties to an appeal are not entitled to adduce additional evidence, whether oral or documentary, save and except in the circumstances expressly enumerated therein. The provision contemplates only 3 eventualities in which the additional evidence may be permitted. First, where the court which passes the decree has refused to admit the evidence which ought to have been admitted. Second, where the parties seeking to adduce such evidence establishes that notwithstanding the exercise of due diligence, the evidence was not within the knowledge or could not have been produced at the time when the decree under appeal was passed. And third, where the appellate court requires any document to be produced or any witnesses to be examined or in order to enable it to pronounce judgment or for any other substantial causes. Accordingly, it is only open upon satisfaction of any of the aforesaid 3 contingencies that an application under Order 41 Rule 27 of CPC can be enacted. Subrule 2 of the aforesaid provisions further mandated that where the appellate court form an opinion that additional evidence is required to be admitted, it must record the reason for such admissions. While illustrating the scope and object of Order 41 Rule 27 CPC, this court, in the opinion in Union of India versus so undertook the exhaustive analysis of the provisions. The relevant extract of is reproduced hereinafter. The general principle is that the appellate courts should not travel outside the records of lower court and cannot take any evidence in appeal. However, and as an exception, Order 41 Rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances. The appellate courts may permit additional evidence only and only if the conditions laid down in these rules are found to exist. The parties are not entitled as of right to the admission of such evidence. Thus, the provision doesn't apply when, on the basis of the evidence on records, the appellate court can pronounce a satisfactory judgment. The matter is entirely within the discretion of the court, and it is to be used sparingly. Such a discretion is only a judicial discretion circumscribed by the limitations specified in the rules itself. Other person is also same. The situation, only on the situation if lordship is think that this additional evidence is necessary to adjudicate the issue involved in this suit. So my case is slightly peculiar, as I'm saying, because lordship in the first suit was dismissed lordship and it was in my favor. Appellate court reversed judgment. I did not get any.
But actually, in the appellate forum,
Yes.
To see it fairly, I mean, in the appellate forum, you had every opportunity to assail the ex parte judgment and seek a remand back for trial on merits or intra parte disposal. But in the even in the appeal, that the appellant lost the chance.
Yes.
So, do you think?
The lordship may admit this appeal, lordship.
Because we have to, as you know, it has to be admitted only on a substantial question of law.
That's true.
But on the face of it, I'm not finding a particular substantial question of law.
Yes, that is why I'm saying, lordship, because where the situation arises.
Let us read this para 38 also. Order 41, Rule 27. The appellate court has the power to allow a document to be produced, but the requirement of the same.
28.
Necessary to this provision first even without this. In other words,
two options are here, lordship, in Rule 28.
this judgment is more closer to our facts. The other one, no, this
In para, lordship,
Jatinder Singh.
Jatinder Singh.
Just a minute, let me read it again. Actually, in this case, the application was not decided. It is required to be decided.
That is why I'm saying, lordship, even if
it is required to be decided.
since this application is filed, lordship, for the timing, this appeal may be admitted, lordship, and notice may be issued in this application, lordship. And also, lordship has the under Rule 28, lordship has the option to, lordship, either to admit this evidence here in appellate court or.
No, if we do not find substantial question of law and the RSF falls, then this will automatically go. You know, so better we keep this pending and issue notice on the IA.
A lot.
That will be better.
That can also be done.
Let them come.
One more thing also is that, lordship, the substantial question of law that I have formulated in my petition. So, lordship, I have gone lots of judgment of apex court, lordship. This question, the word substantial question of law has nowhere decided. only it says that if there is a merit, if there is a material contradiction. if there-
Substantial question of law, not in a general sense, but specific to the
Yes.
specific to the case.
If even if
A question of law which is important in the context of the facts and
yes, but
circumstances,
even if it
which emerges from the pleadings.
law, even if the documents lordship that relied by the appellate court, which impact the right of these parties, that may also be a substantial question of law that I have found lordship in different judgment. So on the timing, lordship may issue notice in this application, and also I have this humble prayer lordship in since they have proceeded execution of this.
No,
With
at
your-
this stage, I think let them appear. You can take steps by Dusty and Speed Post also. Let them appear and oppose whatever they say have to say, right? We keep this pending. And then we'll formulate. In the meantime, if you can come across other substantial question of law, because on the face of it, we do
Basically,
not
the-
find because
yeah,
this
from the material.
That the Lalet trial court held that non-deposit of the checks dilutes the case of the plaintiff and makes it unconvincing. It said like that.
Lordship, not
And
exactly
dismissed.
like that. Trial court has lordship gone through the sex as well as the agreement. Although the agreement was executed, it was not properly lordship registered. It was not a registered agreement, nor it was properly proof. Only the accosting witness were lordship, they used their evidence, but since they were not cross-examined, their evidence remained unrefuted. That on the
So if in an ex parte proceeding,
Yes,
in ex parte proceeding, the notice of course has to be properly seen. But the appellate court believed the exhibit 4
yes,
as well as the unrebutted testimony of attesting witnesses and all that.
But the
So
fact is
from there, per se, to my mind, an substantial question of law per se do not emerge. What will be the question of law that, because that will be a matter of appreciation of evidence, that whether this should have been looked into. If it was a case of, if this was the question, and that such an agreement cannot be looked into without witnesses, then that could have been a substantial question. But the appellate court has already taken into account the testimony of the attesting witness.
But what the first appellate court has decided, lordship, first appellate court relied on the only on the lordship fact that these attesting witnesses has agreed their evidence. It was since it was not cross-examined, it is remain unrefuted. The only issue is that lordship, while deciding a issue or a document, it is a duty of the trial court to the authenticity of the document.
Yeah, ex parte also basic proof has to be there.
Yes, because
Even in
the-
ex parte proceeding, basic proof has to be there.
Yes, but mere filing a suit lordship or without or not appearing a party doesn't mean that his suit will be lordship allowed automatically. He has to stand on his own.
Basic proof has to be there.
Yes.
Anyway, so Mr. J. Kolita,
Lordship.
learned counsel for the appellant. Full stop. The broad facts contended by the appellant side are as follows. Mr. The respondent herein as plaintiff filed a money suit being MS number 32 of 2021 for recovery of a sum of money stated to be rupees 17 lakhs, which was purportedly given to the appellant, given to the defendant by the plaintiff by way of loan.
I have loan.
By way of loan, full stop. The money suit proceeded ex parte. However, the learned trial court was pleased to dismiss the suit. Full stop. Agreed by the said dismissal, the plaintiff preferred an appeal, which was registered as TA number
1 of 2023.
1 of 2023. And the learned appellate court by judgment and decree judgment dated
28/11.
28/11/2024.
25.
2025 was pleased to set aside the ex parte judgment set aside the dismissal of the suit and decreed the suit in favor of the plaintiff appellant for payment of an amount of 17 lakhs by the defendant. Full stop. Along with interest of 4% from the date of filing till date of decree of the appellate court, and further interest of 6% from the appellate decree till recovery of the entire amount of rupees 17 lakhs. The appellant has framed the following substantial questions of law stated to emerge from the facts and circumstances of the case. Page 4 by short page 4 of the appeal. The appellant has also filed an interlocutory application being IA 1597 seeking to invoke the provisions of Order 41, Rule 27/28 of the CPC, seeking to adduce additional evidence. In support of his contentions, the appellant has cited the following decisions. Jatinder Singh, appellant, and this full stop. It is submitted by the learned counsel, Mr. Kolita, that the powers under Order 41, Rule 27/28 can be exercised by the second appellate court as well. And that in terms of the decision in Jatinder Singh Supra, such powers should be exercised in his favor by allowing the interlocutory application. Full stop. Para 4 of Jatinder Singh Supra may be reproduced herein below. Full stop. Thus, I find that in the said case, the High Court was pleased to dismiss the second appeal, but an interlocutory application seeking invocation of Order 41, Rule 27/28 was pending. The Honorable Apex Court was pleased to set aside the judgment of the High Court and remitted the appeal back for fresh decision in the second appeal, along with the application filed for acceptance of additional evidence. At this stage, issue notice upon the I. The applicant appellant shall take steps by speed post upon the sole respondent. Sole respondent. The applicant appellant is also at liberty to resort to dusty service. You want?
No, because person now he is there at UP also.
Okay. Then you take speed post.
Speed post.
Any record will be necessary, no?
I'm saying that they have already initiated execution proceeding. If proceed pleases to
No, because
take
let
the
them,
execution.
because I think
for a time
because the whole question of the substantial questions of law as of now are on shaky ground, actually,
That's
in my
because-
opinion. So only on this aspect, in terms of this decision notice, you notice them, and let's see what happens. This is the matter. After 4 weeks on. July 27.
And the providers.
The issue of the main appeal to the issue of admission of the second appeal on any substantial question of law is kept pending for the moment. I didn't know there was there's a meeting actually at 4:30. So would you like to adjourn these two matters?
Wednesday, my lord, I have some urgency because the execution is going on, my lord, and my lord,
Just a
the
minute.
court is about to issue the writ, my lord.
Which matter? 36.
36.
Wednesday? Because I need to sign a few matters actually before I leave for the meeting. Right.
Your lordship will be taken on Wednesday?
I can take up on Wednesday also. You have formulated the substantial
Yes,
questions of
my
law.
lord, page number 8, my lord.
Page 8.
8.
Just a minute, I'll come to you. Yes, Wednesday can be one option. Yes, yes.
I also filed affidavit, showing the record of the loss of PWS and PWS.
Where's the, which page number?
Page 8, man, 8. Part of the appeal, man. Okay, appeal memo, page 8, man.
Exhibit 5 to 12 where?
My lord, what happened, my lord, they initially, my lord, in the suit, the plaintiff has filed one petition for examining the official from the Tinsukia Municipal Board. That petition was rejected.
For getting a, for summoning an official.
Yes, ma'am.
Okay.
Against that, they have approached this honorable court, my lord. This honorable court says that you call the witness, but without any document. But
Without any document.
Without any document. The order I have annexed, my lord. But the trial court as well as the appellate court has relied on the document.
Brought by the witness.
Brought by
Thereafter the witness came
Yes,
along with document.
allowed, but
Okay.
he has exhibited this exhibit 5 and 5 to 12.
No, only exhibits 5, 6, and 7. Other rest are the exhibits of the plaintiff. 8, 9, 10, 11, 12, and 1 to 4 are the exhibits of the plaintiff. And the defendant number 1 has stated in the deposition that I am the plaintiff of the Municipal Court. I have annexed this cross examination. Immediately, this property is a property of Tinsukia Municipal Court. I was allotted the supervises by the Municipal Board. The PW3, the official witness, and the DW1 has stated that I am the owner and I am paying rent to the Tinsukia Municipal Court. And after considering all the evidence on record, the learned trial court and the appellate court has passed out in our favor. You will see that the examination consequence of the PW3 will be and the DW1.
Anyway, I think that will be best on Wednesday. Take it up on Wednesday, only just one day or something. So could not be the paucity of time, least on Wednesday. What about 37?
37 lordship will be taken up tomorrow lordship. Execution proceeding is lordship pending.
Same, there'll be urgency in all the matters, right?
Lordship, I am 37. Today I have filed the wakalatnama.
That's right.
The sole respondent. Lordship, they may be directed to give us the copy and then a date may be fixed for the substantial question of law.
Hearing on the substantial question of law.
The one that lordship, without issuance of notice, lordship, they have not filed caveat, lordship. Because the matter is urgent, lordship. Lordship, the question of filing a caveat is with
You
respect
filed
to.
wakalatnama? You
I
filed?
filed the
Also, you-
I filed the wakalatnama. That's what I filed today. The wakalatnama has been filed.
You give a copy, then. Not your copy.
Then
We'll take it up there tomorrow or day after tomorrow.
Tomorrow, lordship, it will be. Lordship, yeah. Subject to lordship's convenience.
You are framed of substantial
No,
question.
lordship, I'll be receiving the copy, so I'll request some time to get the instruction, lordship. Let it come after vacation. No, lordship, because lordship, what has happened in this case, the decree has been executed. The decree has been executed. The decree holder went inside the premises. Then the title execution suit was also closed. Thereafter, after the execution case was closed, they again re-entered forcibly. All these aspects has to be brought before the court.
Anyway.
But if that is so, that if they are saying, lordship, if that these things will be
And
brought
Hassan,
before-
learned counsel.
that is the case that the phrase cause of action
Das.
arises, lordship. No, that is a
Counsel
different thing. That
for
will cause of action phrase, lordship.
There's a, okay, no, there's no
The
case.
caveat was on the earlier case.
Stop. No, caveat was an earlier case. Stop the Mr. R. Das, no?
RJ Das.
RJ Das, learned counsel submits that he has entered appearance by filing wakalatnama on behalf of how many sole respondent?
There's only one.
Full stop, and maybe and request for a copy, set of the copies, full stop. The appellant side shall furnish the same, full stop. So you go to Wednesday will be better, I think.
Lordship,
Wednesday.
opportunity maybe you wait on immediately after reopening,
you
we'll
go
file
to
the objection, we'll file the objection and whatever, we'll file the
Can
objection.
it be, my lord, on tomorrow, my lord?
Because-
Because at this stage, my lord, at this stage, this is between the appellant and the court, my lord. If your lordship is satisfied with our appeal, my lord, with the substantial question of law, then lordship will issue notice, then lordship will hear them.
No, Lordship, that is a wrong,
So-
here, if the
So at
stay is
this
granted,
stage-
Lordship,
No,
here,
stay will come
if
in
the
the IA.
stay,
It's not
stay
stay
is
will come in
granted,
the
if
IA.
there is a substantial question of law, stay will be granted. If the stay is granted, whether that is my right, because I am the decree holder. I am the decree holder. Here, Lordship, what I am praying, Lordship, is that today is 23rd, 22nd. Immediately after reopening on 14th, because they have again re-entered the property. This is my instruction. So there is none, they have again re-entered the property. Other things, let those things come on record.
No,
Then
no.
the court will take a
Well,
opinion.
this is not
Because
a-
here it's a just.
Well, this is not a repetition. my lord.
Lordship has
will only
rightly
see
said
whether
on
or
the
not substantial
earlier
question
occasion,
of law is
the
involved.
civil part. When the civil part, they are taking recourse to this procedural part to understand here.
But-
I being a decree holder, I am not able to enter.
But my
So
thing
let
is
these
that, my
things
lord,
come on
this is
record.
my appeal, my lord. My appeal, if your lordship is satisfied,
So,
lordship will issue notice.
substantial question of law has to be seen.
Yes.
Yes,
Yes,
that
whether I
will object to the
Whether I am
substantial
able to
question of law.
satisfy lordship or not, that this matter involves
Decree
substantial question
holder
of
in
law.
many cases, situations have to
Yes.
run years to get the decree.
That's what I have.
To get the fruits of the litigation, you know.
I'm
Anyway,
so obliged.
anyway, either on Thursday or immediately after reopening.
Immediately after vacation,
But
I'll
I
bring
mean-
on record everything which is a subsequent thing.
There is nothing to bring on record, my lord.
Whatever,
No,
the
whatever there
decree
is
has been
there, my lord,
executed.
there
Decree
recorded.
has been executed. That's a very
Executed, but
important
that-
part to the
List on 14.
14. Deeply obliged.
List on 14. All of লিখিব লাগিব বাৰু, পিছত সোমাই দিব লাগিব। Okay.
Deeply obliged.
47.
Wait. 37 আছে না? 37 আৰু আহিব নেকি?